Agreeable. Excellent. So then you have the floor, Mr. Harris, on behalf of the Kingdom of Morocco.
Thank you very much, Mr. President. In order to make the best use of the time available today, I'm going to focus on 4 of our objections in this opening. I will start with objection 3, and I should say my colleague needs to share the screen.
Very good. This is then what you are showing us now is document H1.
Yes, the slideshow.
Yes.
Yes. Just give me 1 second. I just need to move things around on the screen. Very good. So, as I was saying, I will be starting with objection 3, which is what I call the standing objection. And in essence, that objection is an answer to the entire case and can succeed even if you take the claimant's case at face value as to the facts. The essential point is that the claimants were not directly involved in the transactions which form the subject matter of this dispute. And instead, the entities that were involved in those transactions were all, on the claimant's own case, Cayman entities removed from the claimants by 2 or more non-American corporate levels. And that fact alone precludes the claimants from having standing to bring this claim. That is the case as a matter of general international law, as set out in a number of cases, perhaps most famously Postova Banka and Greece, where it was said that an investor has no enforceable right in arbitration over the assets and contracts belonging to a company in which it owns shares. And we bring that quote up on the screen. So that's in general international law and as referred to in that treaty case. But it is all the more so and all the more indisputable under FTA Article 1015(1)(a), because that provides in terms that a claimant can only bring a claim on its own behalf and therefore does not permit claims for reflective loss. And we've put the relevant extract on the next slide, and I'll come back to this, but it's the claimant in 1A, the claimant on its own behalf. And that provision maintains the customary international law position reflected in Barcelona Traction. As the tribunal is aware, importantly, this is not just the Kingdom of Morocco's position. It is also the position and understanding of the other sovereign party to the FTA on which your jurisdiction is based, the United States, as set out in its non-disputing party submission. So that's a précis of objection 3, which I'll come back to in a moment. I'm then going to move on to objection 4, which is the no active making of an investment objection. And I'll take that together with objection 1, which is the contribution, duration and risk objection. And as I will demonstrate, there is no evidence of any active contribution to the transactions in question, including no contemporaneous documentary evidence that any claimant made any financial, know-how or any other contributions to the transactions, apart possibly from some contribution by CCM, the investment manager. And that fact, in my submission, would lead you to decline jurisdiction over the claims of at least 6 out of the 7 remaining claimants, recalling that one has already disappeared from the scene. Moreover, none of the claimants, including CCM, took on any real risk. Indeed, what you will see is that the claimants were very careful to structure their affairs to ensure that all risk fell on third-party investors who are not claimants in this arbitration. And finally, the series of short-term financings that comprise the claimant's alleged investment operation cannot be considered, whether individually or together, to be of a sufficient duration to be considered an investment under the FTA. So that's objections 4 and 1. And the last objection I'm going to deal with is objection 2, which is the ownership and control objection. And what I will demonstrate in that is that the claimant's assertion that CCM, the investment manager, controlled the Cayman entities at the heart of these transactions is simply not supported by the documents or in the relevant legal sense. Now, just one preliminary matter just to remind you of before I get into the substance of objection 3. And that is just to remind you that the parties have agreed a position communicated to you on the 2nd of December 2020 that the evidence of Mr. Suvagia, Mr. Olivo, and Mr. Graybill is to be disregarded for the purposes of establishing whether you have jurisdiction or not. If you don't recall the circumstances of that, I can outline them further, but I don't think it's necessary. It was an agreement between the parties. So you cannot rely and should not rely on their evidence in coming to your decision. So, objection 3, lack of standing. I'll start with the basic transaction structure. And to be clear, this objection applies to both asset categories on which the claimants rely for their investment. That's firstly the commodities that they allege were owned by the company called Q1, and secondly the contractual put rights which they say allegedly were accruing to Q1. Now, the basic factual premise to this objection is very straightforward. The claimant entities, even taking their own case at its highest, suffered only indirect loss as a result of the facts alleged. The entity which, taking the claimant's case at face value, controlled the alleged investments directly and therefore could potentially have suffered direct loss was VMF Special Purpose Vehicle SPC VMF Q1, which we all understandably call Q1. Now, according to the way in which the claimants first presented their claim in their memorial, Q1 was the entity which contracted with Samir, Q1 was the entity through which transactions were financed, and Q1 was the entity which retained ownership of the commodities and put rights which resulted from the transactions at the time of the alleged expropriation. And we've put that's Claimant's Counter Memorial, paragraph 17. We've put it on the slide. So that was their case in their memorial. And they relied for that narrative on the primary document by which the various transactions were governed, the Master Commodities Transaction Agreement, which we've called the Samir MCTA, and which is exhibit CZ0002. Now, sticking with the claimant's case, as they first put it for now, they said that that agreement, the Samir MCTA, permitted Carlyle affiliated entities to purchase oil through Samir and gave them a contractual put right to sell that oil to Samir after a certain period had elapsed. The MCTA, in essence, established a relationship by which Q1 agreed to finance Samir's purchase of commodities. Now, I don't have time to take you through each relevant clause of the MCTA, but I would like to flag how it was supposed to operate by looking at a few of the clauses, which I hope will be of assistance. So if we can pull up the first slide. So this is the start of it. And you can see at the top there, it was entered into on the 22nd of June, 2015. It was initially an agreement between Samir and Q1, but others, and particularly relevant in this matter is 2014-1 and 2015-1, were added as parties separately through joinder agreements. And we bring that up on slide 7. This is the 2014-1 joinder agreement. So as of 16 January 2015, 2014-1 became a party to the Samir MCTA. Now we'll come back to the agreement in more detail, but there are 3 points that are particularly relevant to this objection 3. The first is that, as with many financing transactions, the contractual structure was in the form of a master framework agreement, under the terms of which shorter form confirmations would then be entered into, setting out the terms for each specific transaction, commonplace in financial trading and instruments. And you can see that reflected at clause 2A on page 3, which we'll bring up on the slide. And blow it up. After negotiation of the commercial terms, the VM party shall inform the counterparty, which is Samir, of its desire to enter into the relevant transaction by completing and sending the relevant confirmation. And if we jump on to page 15 of the MCTA, there was an example form confirmation. That's on the slide now. In this case, there were 16 confirmations. They are all at exhibit C0015. I won't take you to them now, but it's common ground that all 16 confirmations were between Q1, which is the Cayman entity I've mentioned already, and Samir. And you can see an example of one on the screen now. This is what the confirmation looked like, and it's Samir and Q1. So that's the first and most important point. Each of the transactions which form the substance of this dispute were entered into by Q1, not by any claimant entity. And it's by virtue of those transactions that the claimants say they indirectly acquired the 2 assets which form their alleged investments: the commodities, which underlay those transactions, and the put rights in those transactions. And you can see those points reflected in the MCTA, turning back to it shortly. On page 3 of the MCTA, if we can bring that up on the screen, you'll see that the next step in clause 3, after I showed you 3A a moment ago, sorry, the introduction to 3, the next step is that once the confirmation has been fully executed, the commodities are then purchased. And importantly, you can see here that the commodities are in practice to be purchased by Samir, which is then obliged to provide evidence of the purchase to the VM party. Once the VM party is happy with those documents, and on the day the commodities are delivered to Samir, the VM party is then meant to pay Samir for the commodities, and title passes to the VM party. That's 3C. So there is the title to the commodities, which is said then to vest in Q1. We then come to clause 3E, and you can see in that clause that during the, and perhaps we bring that up on the screen, that during the exercise period, which is one of the elements set by the parties in the confirmations, the VM party could exercise a put right, which would allow it to sell the commodities or equivalent commodities to Samir. So those are the put rights. Contractual rights accruing to Q1. So neither of the 2 assets which form the claimant's alleged investment was acquired by a claimant entity. Both, on the claimant's case, were acquired by Q1, a Cayman entity. And the tribunal will recall that the claimant's case is for loss of the commodities and the put rights in August 2015. And we've put on the next slide the claimant's memorial, paragraph 181, where they set that out. I don't think that's a point we need to spend long on. And the claimants reiterated that those 2 alleged investments were acquired by the Cayman Islands entity Q1. They repeated that in their rejoinder, and we've put that on the next slide, paragraph 54. So it's their own case. The Cayman entity Q1 acquired both of the alleged investments. So that begs the question, what was Q1 and how did it relate to the claimants? And if we bring up the next slide, we start with the beginnings of our structure chart. Now, Q1 is said to be the ultimate subsidiary of 5 out of 6 of the remaining claimants. And you can see that the nearest of them is 2 non-US corporate levels above Q1, and that's the onshore feeder, which is in green. So the US entity, the claimant entities are in green, and we've tried to indicate where entities are from in the chart by writing Cayman or Delaware or whatever after them. But broadly, the bottom half is Cayman and the top half is US. In fact, Q1 is at the bottom of what is quite a common master feeder structure. And if we go to paragraph 3.1 of Mr. Travers' report, we can see there a simple description of what a master feeder fund structure is. If we bring that up on the screen. In essence, I mean, this tribunal won't necessarily need my help on this. In essence, it is used to allow different investors from different jurisdictions, subject to different requirements, regulatory and tax, to invest in the same asset pool. So it was a structure which intentionally put some different distance between the initial investor and the ultimate investment in order for certain tax and regulatory benefits to accrue to the investor. And Mr. Travers set out a diagram showing the typical Cayman Master Feeder Fund structure at page 14 of his report, and we've put that on slide 17 to demonstrate that. And you can see there that you have an onshore feeder fund, a Cayman feeder fund, and a master fund, and then a subsidiary joint venture vehicle, and then the investments. And that was typical and exactly the structure that we have here. The structure above Q1 tracks precisely the structure which Mr. Travers set out in his chart, and we can bring that up again, go back to our table. So you have at the bottom, immediately above Q1, you have a company called Celadon Commodities Limited. That's the master fund, and it's a Cayman Islands entity, and that's said to own 100% of the participating shares in Q1. Q1, in fact, has 2 types of shareholders: shareholders holding management shares and shareholders holding participating shares. Now, we know about the 2 classes of shares because we have the audited financial statements of the Cayman company, Celadon Commodities Limited, for 2015. That's C0034. And despite us raising the point, quite remarkably, Carlyle has declined to indicate or provide any evidence as to who held the management shares in Q1 at the relevant time. And so we've put a question mark because we just don't know. But you can infer from that, in my submission, that they were not held by any US entity, because if they were, you can be sure that we'd have heard about it. We do know who held the participating shares in Q1, and that's the master fund. And above the master fund are the 2 feeder funds. The one to the right is the offshore feeder in Cayman, and the one on the left is the onshore feeder, which is the first US entity and the closest claimant entity to Q1. And you can see there that the onshore feeder is nevertheless 2 corporate levels away from the underlying investments. Now, sitting above those feeder funds are most of the claimant entities, with the exception of the investment manager, which I will come on to later. So we don't show the investment manager on this slide, but that shows you the relationship between the other entities. Now, as I will come on to show you later, it remains wholly unclear here on the first day of this jurisdiction hearing what any of these passive parent companies or related companies did, if anything, with respect to these transactions. But pausing there, you can already see how far away from Q1, let alone the underlying investments, alleged investments, these entities are. And it's that link with Q1 on which the claimants rely to establish a jurisdiction. In their rejoinder on jurisdiction, they called our discussion of the role played by 2014 one and 2015 one, which I'll come on to in a moment, a red herring. They told you that these were not at all relevant for the purposes of jurisdiction, and that all that is needed for jurisdiction is that the claimants committed capital for the purchase of commodities through the US onshore feeder, and that the claimants controlled every aspect of the transactions through CCM. That's paragraph 62 of the rejoinder, which we've put on the next slide. As we've seen, the onshore feeder is the entity up the chain from Q1. So if Q1 suffered a loss, the only category of loss for which these entities, even the onshore feeder, could claim would be a reflective loss. And that indeed appears to be accepted by the claimant's key witness, Mr. Zuech. Because at paragraph 23 of his third witness statement, Mr. Zuech said the following, and we bring it up on the screen. The US onshore feeder held nearly all, 99.96%, of the participating shares in the master fund, which in turn owned 100% of the participating shares in Q1. Through these participating shares, the US onshore feeder held an interest in the assets of the master fund and in turn the assets of VMF-Q1. Due to Morocco's actions, the value of shares in VMF-Q1 held by the master fund decreased. And in turn, the value of the shares in the master fund held by the US onshore feeder decreased. That, gentlemen, is almost a textbook definition of reflective loss. And it is the only loss for which 5 of the 6 claimants could possibly claim. The same is true for the final claimant, CCM, the investment manager, but for a slightly different reason. If it suffered a loss, and the claimants haven't claimed any loss, specifically alleged to have been incurred by CCM, separate from the others, then it could only be the loss of fees potentially owed to it by Q1, which Q1 was rendered unable to pay by virtue of Q1's own direct loss. Again, if it existed, that would be an indirect loss, not much different to the type of loss a law firm advising Q1 would also have incurred if Q1 had been rendered unable to pay its fees. Not an investment claim at all. Now, turning to the law, because as you can see, the facts underlying objection 3, our standing objection, are not in dispute, and you'd not be called on to decide any contested matters of fact in order to resolve it. The entity which held the assets which formed the claimant's alleged investment is a Cayman entity, which on their own case was owned indirectly by them, i.e. Q1 owned indirectly, they say, by the onshore feeder. The loss which they say they suffered was reflective in nature. It was allegedly a diminution in the value, in the share value up the corporate chain, said to have been caused by a direct loss suffered somewhere further down the corporate chain. And those facts mean that as a matter of law, the claimants lack standing to bring this claim. Now, we set out in our written submissions the general international law basis on which we say that, and I showed you previously the extract from Posta Banca, and it has been put very simply in subsequent cases too. We've put on the next slide an extract from STAD in Bulgaria, RL009, where the same point is made, repeatedly held by arbitral tribunals, that an investor has no enforceable right in arbitration over the assets and contracts belonging to the company in which it owns shares. But the second basis on which we make this argument, and on which I want to concentrate in the short time we have, is FTA Article 10.15.1, which is the provision of the FTA on which the claimants rely to bring their claim. It's common ground between the parties that the framing of that provision reflects the distinction drawn in NAFTA Articles 1116 and 1117. We can see that at paragraph A of FTA 10.15.1, the provision on which the claimant's claim has been brought, that reflects NAFTA Article 1116, and we bring up the slide, we can show that. The key element is that in both cases, an investor can bring a claim on its own behalf, that it has suffered loss and damage on its own behalf. And there's an alternative basis under 10.15.1b, which reflects NAFTA 1117. We'll bring that up on the next slide. And that's where the claimant brings a claim on behalf of an enterprise in the host state that is a juridical person that the claimant owns or controlled directly or indirectly, and that may submit. Now, we don't have to worry about that too much, except that it informs the overall interpretation, because no claims made on that basis. In our reply at section 5b, we explained the difference between 10.15.1a and b, and why that difference is important. And in short, it has been drafted to ensure that paragraph A preserves the default position of international law as famously expressed by the International Court of Justice in Barcelona Traction, which is exhibit CS 0146, paragraph 44, which we've put on the next slide to make it easier for you. And I'm not going to read it out in the interest of time. It's an important rule of customary international law, and as such, it cannot be held to have been tacitly dispensed with in the absence of any words making clear an intention to do so. And there I'm quoting the Electronica Secula case in the International Court, which we've put on the next slide. Now, returning to the rule, so long as it applies, a claimant cannot bring a claim for reflective or indirect loss. It can only bring a claim for loss and damage that is incurred by it directly. Put another way, Q1 could claim potentially for loss it suffered by reason of damage to its assets. But even its direct shareholder could not claim for those losses. Only Q1 could claim for those losses. And that is what the requirement that a claimant can bring a claim only on its own behalf means. And you can also see that, as I said earlier, in subparagraph B, which confirms that reading of paragraph A, because paragraph B is a limited exception to the rule in Barcelona Traction, which allows a claimant to bring a claim on behalf of an enterprise, so long as that enterprise is an enterprise of the respondent. Put another way, it allows a claimant to bring a kind of derivative action on behalf of a company incorporated in the host state of the alleged investment that it owns or controls. But there's a catch. And you can see that catch at Article 10.25.2 of the FTA, which we can bring up on the screen now. Any amounts recovered by the claimant on a claim brought under paragraph B of 10.15.1 must be paid directly to the host state enterprise. And that's so the position of other stakeholders in the enterprise, for example, shareholders and creditors, is not prejudiced. So that's an exception that proves the rule of A. And this was recognized by the tribunal in Bilcon in Canada, exhibit RL 0011, dealing with, admittedly in that case, the distinction between NAFTA articles 1116 and 1117. And we've got the quote from paragraph 389 of that award on the next slide. Articles 116 and 117 are to be interpreted to prevent claims for reflective loss being brought under Article 116. And you will notice there as well that particular weight was placed in the last sentence of that quote on the non-disputing party submissions that have been filed in interpreting NAFTA Article 1116. And the same is true in this case. This tribunal is in the same position. The US submission unequivocally supports and agrees with the Kingdom of Morocco's understanding of FTA 1015(1)A. Perhaps we can look at that briefly together. At paragraph 2 of the US submission, you will see an acknowledgement of what I've just described, that paragraphs A and B of FTA Article 1015(1) proceed on different jurisdictional bases, and only claims for direct loss and damage can be brought under A. We bring that up on the screen. Where the investor seeks to recover loss or damage that it incurred directly, it may bring a claim under 1015(1)A. That's paragraph 2 of the US submission. Next paragraph of the US submission, they confirm that FTA 1015(1) was drafted with the rule in Barcelona Traction in mind and does not derogate from that rule, save in paragraph B. In paragraph 4, there's a very important point about what constitutes direct harm for the purpose of this provision. And I say it's important because it confirms that a claimant cannot simply reformulate, repackage its claim to try and move the loss further up the chain. And bring that up. How a claim is characterized is not determinative of whether the injury is direct or direct. What is determinative is whether the right that has been infringed belongs to the shareholder or the corporation. At paragraph 5, you can see what the US means when it talks about rights in this context. It means rights in domestic law that arise out of the alleged investment. And that will seriously limit the availability of shareholder claims to rights emerging directly from shares, as opposed to indirectly from their tradable value, for example. And that's the examples that the US gives, which we've put on the slide. So a shareholder to seek direct loss when it alleges that it was denied a right to a declared dividend, or denied the right to vote its shares, a shareholder right. Or if the shares themselves are taken. And this, members of the tribunal, is precisely the Kingdom of Morocco's position, as we set out in our reply on jurisdiction at paragraphs 264 to 266. Article 1015(1)A preserves the rule in Barcelona Traction and entitles the claimants to claim only with respect to direct losses suffered by them, not indirect losses at all. The two sovereign parties to the FTA are in violent agreement as to what 1015(1) means. And we say that's what the Vienna Convention on the Law of Treaties, Article 31(3)A, describes as a subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions, or 31(3)B, it's a subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. We put those on the next slide. Now, importantly, such an agreement must, I emphasize must, be taken into account when interpreting the FTA, and may even be said to constitute an authentic interpretation of the FTA. And I'll make that good. When commenting on the provision that would become Article 31(3), the International Law Commission, in its commentary to the draft articles on the law of treaties, which is Exhibit RL 0109, noted, and we'll bring it up on the slide, an agreement as to the interpretation of a provision reached after the conclusion of the treaty represents an authentic interpretation by the parties, which must be read into the treaty for the purposes of its interpretation. And we've also included in the authorities an article by Judge Crawford, RL 0111, which emphasizes the importance of such interpretative views of the two contracting states, and put that on the next slide. And I can take it shortly, because what he's saying is a treaty is the creature of its creators, the two states parties. It's not the investors' treaty. And if the two states parties say this is what it means, that's what it means. One might say within reason, he says at the end, but one might not question their application of reason as they see fit. So the claimant's case rests on the alleged loss of commodities and put rights, but even on their own case, none of the claimants ever held those rights. They were assets belonging to a Cayman entity, Q1, with no standing to claim under the FTA, and accordingly not a claimant. So any losses that the claimants suffered on their own case were suffered indirectly, and therefore the claim is, there's no jurisdiction for the claim. They have no standing. And it is indeed striking in that regard, members of the tribunal, that the claimants also recognise this huge issue for their case. That is why one of the claimants, the onshore feeder, made a late-breaking attempt to reformulate its claim of indirect loss into one of direct loss in paragraph 163 of the rejoinder. There, the claimants say, for the first time, that the onshore feeder suffered a direct loss because it owned 99.96% of the master fund, which in turn owned 100% of Q1. We've put that on the next slide. It's a direct loss, they say. But that is a transparent attempt by the onshore feeder to dress up an indirect loss as a direct loss. As Morocco's reply and paragraph 4 of the US submission, not to mention Postova Banca and the other cases, make clear, you cannot simply recharacterize a loss or damage and thereby circumvent the limitations imposed by the treaty parties on who can claim and how under their treaty. Otherwise, the limitations that the two treaty parties specifically agreed in 1015-1 would be purely formalistic and illusory. And as the US submission with which the Kingdom agrees makes clear, the real question is one of substance. As a matter of domestic law, do the rights alleged to have been infringed belong to the shareholder or the corporation? And here, all the rights so infringed belonged to Q1. On the claimant's own case, it held title to the commodities, and it, and not the claimants, was a party to the agreements that contained the put rights. They were Q1's rights. As such, only Q1 can claim in respect of them. If the onshore feeder's shares in the master fund were a protected investment, that might give it the starting point for a claim. But for the purposes of the FTA, they are not a protected investment or claimed to be one. Thus, the position is that the claimant's claim for indirect losses, which on their own case was suffered by a Cayman company, not them. And when faced with not one, but both of the treaty parties telling you that such claims cannot be brought under FTA Article 1015-1A, the claimant's only attempted answer is to tell the treaty parties that they're both wrong and that they concluded a different treaty than the one which they both intended and understood, despite its language and despite the clear genesis of that language through the well-established provisions of the NAFTA. And before I move on from this objection, I just want to address you shortly on the position taken on this issue in the Mason and Korea case, RL 0022. In that case, Korea has put forward a similar objection to the one that we are now making. In Mason, it was advanced under Article 1116.1 of the US-Korea FTA. And in that case, that objection was not decided by the tribunal in its decision on preliminary objections, which was at a different stage. It wasn't the same situation that we're in here, a fully bifurcated jurisdictional phase. It was that accelerated, very narrow jurisdictional phase that you can have under these US FTAs. Now, I'll return to this in closing if need be, but it is clear that, and important for you to understand, that the Mason and Correa case is nothing like the present one for very important reasons. And I can just show you this quickly on the next slide. The left-hand side shows the corporate structure in the Mason and Correa case. And the right-hand side shows, more importantly, the division of proprietary interests with relation to the relevant investment. So that case was about an investment in Samsung shares in Korea. And the US claimant had the general partner interest in a Cayman fund. The Cayman fund was a Cayman limited partnership. And that's very important. That's not what we're talking about in our case. And the reason it's so important is that the Cayman LP has no legal personality and cannot hold the relevant investment, the shares, on its own account. And that resulted in the claimant holding the direct legal title to the investment. Under the terms of its agreement with the limited partner, another Cayman entity, which is also there on the slide, Mason Capital Limited Cayman, was the claimant, which is the top left general partner, was entitled to an incentive allocation with respect to at least some of the investment. And the Mason Tribunal equated that preliminarily to a beneficial interest in those shares affected by the incentive allocation. And the remainder of the beneficial interest in the shares was held by the limited partners of the Cayman Fund. So in Mason, you have a position where the general partner satisfied the tribunal that it directly held 100% of the legal interest in the investment, and that it directly held a beneficial interest in a part of the investment through the substantial incentive allocation. And you can see on the slides where we get this reasoning from, but if you want a more detailed understanding of the case, the relevant passages start at paragraph 135 of the decision. Now, you will appreciate that's very different from our case. Q1 is a Cayman company. It has legal personality. It is capable of holding assets in its own name, and it did. It is not an LP that needs a general partner to hold assets for it. Any harm to Q1's assets is felt in the first instance by Q1. And at no point have the claimants asserted any kind of direct interest in the put rights and commodities. So on the facts, Mason is radically different. And in fact, the difference serves to emphasize why our objection 3 is right and must succeed. Now, the claimants have not claimed in their pleadings that Mason supports them on this point, but I just wanted to explain it to you in case there should be any attempt to rely on it in the claimant's opening in a way that doesn't identify that fundamental underlying factual situation. Now, moving on, as we pointed out in our reply, investment treaty protection is not as of right. Putative investors have to satisfy the preconditions set out by the treaty parties before they can take the benefit of the treaty. The claimants chose their structure. They did so for various reasons, tax reasons, perhaps some other advantages they perceived. That tax and other structuring has the consequence that the claimants are not protected investors with a protected investment under this treaty. That's their own free choice, and they have to live with that. It is certainly not for Morocco to compensate them, notwithstanding their choice. They cannot have their cake and eat it. And so for all those reasons, in our submission, the tribunal must hold that it lacks jurisdiction over the claimant's entire claim. Even if we take the claimant's case at face value, it simply cannot be brought under FTA Article 1015(1)(a). So that's objection 3. Now objections 4 and 1. The no active making of investment, no contribution, durational risk.
Mr. Harris, how long can we get the time check? I think you have been going on for more than an hour.
No, 45 minutes, sir.
Okay, that's fine.
I apologize if it feels...
Sorry, I looked, it was my mistake. You are right, only 45 minutes. Sorry, I withdraw my comment.
So, as I said, objection 3, the standing one that we just dealt with, that succeeds even if you take the claimant's case as they've put it. But unfortunately, the claimants haven't been entirely straight with you as to the facts underlying their case. Objections 4 and 1 are legally straightforward objections, but require a little bit more of an exposition of the facts, if you bear with me. These are both objections concerned with the nature of the claimant's alleged participation in the alleged investments, of the claimant's alleged connection with the investments, which is why I deal with them together. And there are 3 important factual points relevant to these objections. The first is that the transactions were not, as the claimants would have you believe, a way for Q1 to acquire oil and store it in Morocco. These were short-term financings in which the underlying commodity was only of security interest to the claimants. The second is that the claimants have provided no conclusive evidence that any of them funded any of the transactions which are the subject of this dispute. The source of the funding for these transactions remains in part something of a mystery. They have also failed to provide any evidence that any of the other claimant entities, apart from CCM, made any type of contribution at all, even beyond the financial contribution. The third factual point that's important is that in addition to being passive with respect to the alleged investments, the claimants seem to have put in place a parallel financing structure designed specifically to transfer the financing obligations and the risk inherent in these transactions away from the claimants. That's obviously of critical importance. So I'll start first, if I may, with the nature of the bargain between Samir and Q1. And that bargain was not, as I've said, as they would have you believe, a deal between Samir and Q1 by which Samir sold Q1 oil. In fact, the contractual structure that I've already described to you was something of a fig leaf for an altogether different structure in practice. Carlyle is an investment group which manages assets. It doesn't own assets or invest itself. What that means is described in some detail at paragraphs 36 to 60 of the expert report of Vassant Partners, where Mr. Deguiar, an experienced fund manager, explains how the Carlyle Group generates its revenues. And as he explains, there's a difference, which this tribunal will be familiar with, between proprietary investment managing, where a company invests with its own funds and takes a significant risk, and the alternative of managing funds of third-party clients, in which case the investment manager does not typically have a direct exposure to investment risk. Now, Carlyle falls very firmly into the latter category. And we've put on the slide an excerpt from paragraph 60, which rather summarizes that point. Now, Mr. Deguiar, of course, has not been called for cross-examination by Carlyle. So you won't get a first-hand opportunity to have him explain to you how fund managers work as an independent expert. But I do invite you to read his report and, importantly also, Mr. Travers' reports on Cayman law and these structures, which are very informative because they contain important information about how these types of businesses structure their dealings. Now, to try and assist you with some of the key points, on the next couple of slides, we've summarized some of the key points from Mr. Travers' supplemental report, which we can show you in terms of directors' roles and in terms of the nature of the different companies. And the point really is that it's extremely important that this evidence isn't overlooked simply because the claimants were afraid to call these experts and examine them. In fact, we say that should only emphasize to the tribunal quite how important their evidence is and that the claimants have no real answer to it. And if you were to take just one thing away from Mr. Deguillar's report, it would be the information at figure 4, paragraph 48 of his report. And what you see in that figure is that for 2014, out of total revenues, can we put it up on the screen, please? Out of total revenues of $3 billion US, a grand total of 0% was generated by investment income. The phrase investment income denotes income from investments in which Carlyle invested its own money, put its own capital at risk. And that just goes to demonstrate Carlyle doesn't invest its own funds, it manages the funds of others. And that is also supported by evidence that you have on the record before you. If you look at exhibit CZ0032, which we can bring up, this is the brochure put out by CCM, the fund manager. You can see the date, 31 August 2015. And it says that the brochure provides information about the qualifications and business practices of CCM. If we go to the next slide, you see page 32 of the same document, the highlighted language. The advisor, which is CCM, has no proprietary trading accounts and therefore does not invest in the same or related securities in which the funds are invested. So you see the point. It's a company that manages other people's investments and covenants with those investors that it won't invest with its own money. Now, in late 2014, Samir was a privately owned refinery in Morocco, which was on the verge of bankruptcy and had been for some time. It was desperately looking for sources of liquidity in order to allow it to continue trading. It appears as though the Carlyle Group smelled an opportunity to make some money for its clients, and the two sides began to talk about putting in place a short-term financing facility. And I'll show you a couple of documents now that make absolutely clear that what the parties were talking about here was a financing, a provision of liquidity, rather than any real oil trading by Carlyle, as it now suggests. Now, the first document I want to show you is protected information. So for the first time, I raise my hand and say protected information.
This is confidential.
Thank you. The next document is CZ001, which is on the next slide. And this is the approval for these transactions by the Office d'Échange, the Foreign Exchange Office of Morocco. And the English translation is at page 5 of the PDF of CZ001. You can see the subject is to open a line of credit, a credit line of $350 million on behalf of your company in relation to crude oil imports. In the first paragraph of the letter, in relation to financing your crude oil exports. So this is what Samir was saying to the Office d'Échange, and the Office d'Échange was responding, setting out its understanding of what it was being asked to agree, these fund flows. It's very clear Samir needed help financing crude oil, and it was offered a structured financing through repo commodity financing by Carlyle. And you also have, in the next slide, a pre-contractual letter from a director of Vermilion, which says, who refers to these transactions as a way to provide liquidity. Now, it's striking, if not surprising, that this simple proposition, that these were short-term repo financings for Samir to raise liquidity, is being challenged by the claimants in the face of the contemporaneous evidence and the obvious reality. But the reason for that, the reason the claimants cannot accept that they're repo financings, is because that would cause real problems for them for two reasons. Firstly, and as highlighted by the US submission at paragraphs 12 to 15, the FTA makes clear that not all financings will be investments. You can see that, that's at footnote 9 under Article 10.27 of the FTA, which we can bring up on the slide. So some forms of debt are more likely, so long-term notes, debentures, bonds, more likely to have the characteristic of investment, while other forms of debt, are less likely. So it's fact specific. And short-term repo financings, less likely to have the characteristics of an investment, clearly. But secondly, even if the financings are investments, they're governed by Chapter 12 of the FTA. And the investment protections for such investments, according to Article 12.12 of the FTA, which we can put on the screen, are more limited than for those for non-financial investments. So you only can claim for expropriation, transfers, denial of benefits, and information requirements. There's no FET claim, for example, in relation to financial investments. So that's the first point I wanted to make. It maybe that's exactly an hour in. Maybe that's a good point to take the short break before I move to the second and third points.
Very good. Thank you, Mr. Harris. Let me get you a time check from the secretary, and then we break for 5 minutes.
Dr. Harris, you've spoken for 59 minutes and 33 seconds.
Well, that was a very good timing if you were aiming at 60 minutes. Very good. So, sorry.
You said it's my Swiss side.
Very good. So that it is now 15:45. Yes, 15:45. So we will be back at 15:50. That is Spanish time. That should be 20 to something wherever the different time zones are. Thank you. Mr. Harris, you have the floor.
Thank you very much, Mr. President. So I've dealt with the first point, which is the fact that these were short-term financings. The second factual point is that there is no evidence of funding or other contribution. The funding for these transactions, the liquidity at the heart of these transactions, there's no evidence before you that that came from any claimant entity, nor that any claimant entity made any other type of contribution to these transactions. And it's helpful to return to the structure chart of the master feeder fund, which I showed you a little earlier. Can we bring that up on the screen, please? And the point, in short, is this. The claimants have provided no evidence at all that any of the entities which appear on this slide, any of the green entities, so any of these claimants, which only leaves out CCM, provided any funding for any of these transactions. Now, to recall, the earliest of the transactions with Q1 was concluded on the 10th of March 2015, and the last was concluded on the 23rd of July 2015. And we've put on slide 53 a table just scheduling those out for the tribunal's convenience. And that's one of our demonstratives. And that means that if the claimants wanted to show you that they'd funded the transactions, they would have needed to provide you with evidence of money being committed by them for the purposes of funding the transactions prior to the 10th of March 2015, and certainly by the 23rd of July 2015. Now, that ought not to be difficult, especially for a sophisticated, regulated financial giant like Carlyle. But the claimants have done no such thing. They only even attempt to show you that one claimant entity provided any funding for these transactions, and that's the onshore feeder. And the case in that regard is that some part of the cash spent on the transactions was transferred to Q1 by the onshore feeder. And in support of that assertion, they rely on two documents. So in order to prove that the onshore feeder invested in the master fund, the claimants rely on a financial statement which reflects the onshore feeder's cash position as at 31 December 2015. So some 5 months after the last of the transactions had been entered into. And that's exhibit C0032, bring it up on the screen. And what that document shows is simply that by the 31st of December 2015, the onshore feeder had a stake worth 184 million in the master fund. But that is not probative evidence of any contribution of finance at any time, still less a contribution of funds by March 2015 or July 2015 for the purposes of these transactions. At best, it might be taken as evidence that at some point, at some unknown time, a structure had been created whereby the onshore feeder had rights in the master fund established, which they are valuing at this date, 31 December 2015, at 184 million. Tells you no more than that. It's the claimant's burden and they failed to meet it. And they used the same trick for the next entity down the chain in order to try and show you that the master fund, which remember is a Cayman entity, so this is US entity's stake in a Cayman entity, and then when we go down to the next level, the interest of the master fund Q1, to try and show you that the master fund contributed money to Q1, they again rely on an audited financial statement of the master fund as at 31 December 2015. That's exhibit C0034, pages 9 and 29 in particular. And we can bring it up on the screen. It shows that the master fund held a stake valued at $157 million in Q1 at the 31st of December 2015. But again, that tells you nothing about what, if any, payment was made at any particular time by by the master fund to Q1, or that any part of that amount was used to finance the transactions. For all we know, it could have been derived from contributions of others to Q1, from completely other transactions. So again, the claimants have simply not met their burden. Now, why do I say that's relevant? Well, because if the claimants wanted to show you that the onshore feeder transferred money down to Q1 in time for it to finance certain of the transactions, then they would have had to demonstrate that as at March 2015, or whatever transaction they were specifically going to rely on, that money had come in. Showing generally that the onshore feeder has some sort of interest with a value in the master fund just doesn't get you there. It doesn't show that the onshore feeder contributed to any of the transactions. Indeed, you'll note by yourself that almost half the year of 2015 took place after the last transaction at the end of July 2015, before the date of these two statements. Now, that might sound in some respects like a rather technical point, but in my submission, it's part of a fundamental issue with the claimant's case that the tribunal will see again and again. They make assertions and provide what they assert to be evidence of points, which when we do a little bit of probing, turns out to be simply wrong. I'll give you one important example. We now know that the onshore feeder was owned at the relevant time by the state of Maryland's pension system. Now, prior to that counter memorial on jurisdiction, the claimants had positively asserted that the onshore feeder was wholly owned by TC Group LLC and TC Group Investment Holding LP, two other claimants. It's footnote 3 of the memorial. We've got it on the next slide. It was only when we pointed out in our memorial on jurisdiction that the evidence of TC Group LLC and TC Group Investment Holding LP's ownership of the onshore feeder dated from 2016, that the claimants disclosed evidence as to the position in August 2015 in their memorial on jurisdiction, paragraph 44, next slide. And when they did, it became clear that what they had told you and us in their memorial was wrong. It was factually incorrect. In their counter memorial, the claimants revealed that it was the state of Maryland's pension system which owned the onshore feeder, not TC Group LLC and not TC Group Investment Holding LP. And it was that Maryland pension system which had provided, quotes, virtually all the funds used by the onshore feeder. Can we bring that up on the slide, please? So we can add the Maryland pension system to the structure chart. Now, the claimants had kept the Maryland pension system's existence entirely hidden in the initial rounds of pleadings. And that underlines the reason why we keep reiterating to the tribunal that it simply cannot take the evidence and submissions of the claimant at face value. If the claimants have chosen not to reveal evidence of the fund flow from the onshore feeder to Q1 prior to the 31st of December 2015, then it is to be inferred that they are holding something back because the true position is against their case. And that's just one example of the misstatements that we faced in this case from the claimants. There are many others. I don't propose to look at them all in detail, but we've put a couple on the next slide just so that you keep them in mind. The second one, you can see we were told initially that CIM was the sole parent company of and directly owned and control 100% of the economic interest in 2014-1. Turns out it didn't even acquire the interest until 2017. So with that context in mind, if the onshore feeder really did contribute funds to Q1 in the first few months of 2015, in time for Q1 to use them for the repo transactions, why have the claimants not been able to produce any evidence to show that? And to be clear, they've provided no evidence at all of any funds coming from any other claimant entities. So there's not even an argument that any other claimant entity provided any funds. And neither have they provided any evidence of any other type of contribution, know-how or anything like that, whether by the onshore feeder or any of the other claimant entities above Q1. Now, we've already seen the Maryland Fund, which we now know owned the onshore feeder at the relevant time. And the revelation of its role meant the two entities previously asserted by the claimant to have been the onshore feeder's owners, the two TC Group entities, in fact only played a nominal role in the structure. They seem to have had a nominal direct interest of 0.03% of the limited partnership interest in the onshore feeder between them. And the same two entities seem to have held indirectly 0.04% of the limited partnership interest in the master fund. The claimants have produced not a shred of evidence reflecting any form of active participation by these two entities in the alleged investments. And it's safe to infer from that, and from the late revelation of the role played by the Maryland pension system, that neither TC Group nor TC Group Investment Holdings did in fact contribute any money to these transactions, nor otherwise actively participate in them. And certainly the claimants haven't established that. And the same is true for the two other entities, Celadon Partners and the Carlyle Group LP. There's just no evidence at all that they did anything or contributed anything in respect of the transactions. Now move to the third point, because the problems with the claimant's case don't stop there. Not only did these entities not make any active contributions to these investments, in fact, an entire corporate and funding structure was put in place precisely in order to shield these claimant companies from having to make any contribution or take any risk. And the key to that is the entity called 2014-1. And you'll recall that the completed transactions under the MCTA involved Q1 providing funds for the purchase of commodities as soon as they reached the port in Morocco. And Samir was meant to provide ownership of the commodities to Q1, which would then pay Samir for the commodities and take title to them. But in practice, that is not how the financing worked. In practice, no funds at all were paid directly to Samir, as far as we can see on any of the evidence. And no funds were paid directly by Q1. Instead, all payments were in the form of letters of credit, all of which were issued by 2014-1, the Cayman entity in the separate structure. And the letters of credit were issued, as far as we can see, directly to the seller of the commodity in each relevant transaction. Now, you have the applications for the letters of credit and the letters of credit themselves in Exhibit C45. And we've put an example on the screen in the next slide, just so that you have an idea of what it looks like. And you can see It's quite small, but you can see that it is at 2014-1 in the top box, which is asking the bank to do it in favor of BP Oil for the account of Samir. And we've added these letters of credit to the chart that we looked at before. We can bring it up. There are the highlighted yellow is the origin of all of these letters of credit, 2014-1, apart from the last 3 transactions where we have no information about them at all. Now, why is that relevant to your jurisdiction? Well, on its face, it rather implies that all of the financing for these repo transactions came from 2014-1. And as we have seen, the claimants are having a hard time proving by any reference to any documents, and documents which they really ought to have readily available, that any claimant entity transferred any cash to Q1 in time for or that was used to finance repo transactions. And we have the evidence that 2014-1 was the evidence that provided all of the financing through the letters of credit. And at exhibit MO001, there's an email chain between Samir and some of CCM's executives dated 15 December 2014, so before the signature of the MCTA. And we can put the relevant parts from pages 3 and 4 up on the slide. There's an explanation from Mr. Olivo as to how these transactions work. And you can see that email, Mr. Olivo defines 2014-1 as CGM-SCF, Carlyle Global Market Strategies Commodities Funding 2014-1 Limited. And then at the first sub-bullet of the second point on page 4, you can see his explanation that Q1 will direct 2014-1 to make payment based on Samir's instructions, meaning that 2014-1 will be the entity that opens the Bank of America LC on behalf of Samir to Aramco and the other sellers. So in other words, Mr. Olivo is confirming that the funding for these transactions is coming from 2014-1. Now, pausing there, if 2014-1 is the entity which financed the transactions, it's important to understand what is 2014-1 and how was it connected to the claimants. Go back to the structure chart. And again, I have to raise my hand. I need to look at some protected information now. So if the US could please be removed from the hearing. Thank you. So as I was saying, the claimants quietly discontinued CIM's claim in the footnote of their counter memorial, having been caught with their hands in the cookie jar, as I believe they say over there. Instead of owning up to it, they made it worse by saying that this was just to streamline things and simplify the issues. They were withdrawing it as a claimant. But that concession makes clear that the structure above 2014-1, which we call the financing structure, had nothing to do with any of the claimants at the relevant time. And we now know, thanks to the careful work of Mr. Travers, that 2014-1 was in fact owned by Appleby Trust Cayman Limited, another Cayman company, which held all the ordinary shares in 2014-1 as share trustee. And we've put that in the reference to Mr. Travers' report on the next slide. And we can show that in the structure chart. Now, Appleby Trust has nothing at all to do with the claimants. You don't need to worry about it further for the purposes of this jurisdictional phase. We also know that 2014-1 issued debt instruments, and those debt instruments were bought by investors, the identity of whom remains undisclosed by Carlyle. They're represented by the box labeled third-party foreign investors here. And according to the claimants, some of the note holders were US investors and some were not, but we have no information about that. And none of them is a claimant in any event. And so the extent, if and to the extent the claimants base any part of their claim on 2014-1's financing of the transactions, it will be bound to fail. 2014-1 simply wasn't connected to the claimants at the relevant time. But it didn't make sense to us that 2014-1 would be providing the financing for the repo transactions without some sort of arrangement between 2014-1 and Q1, setting out the terms on which that was happening. Again, with the assistance of Mr. Travers, we managed to deduce in our memorial on jurisdiction that there must have been a back-to-back transaction or a series of back-to-back transactions by which 2014-1 took title to the underlying commodities in exchange for the financing. And we set that out in paragraph 30 of our memorial, which is on the next slide. Not that this fact, of course, hadn't been mentioned by the claimants. And we raised this fact with the claimants fairly and squarely, as you can see, and we raised the fact that they had failed to provide any documentation governing those back-to-back transactions. We put that on the next slide. It was in our annex when we identified a number of missing documents. And our deduction was confirmed by the claimants in their counter-memorial on jurisdiction when they finally revealed that they'd only been telling us and you half the story once again. We can show that counter-memorial paragraph 28. In fact, as it turned out, sitting behind the contractual framework which the claimants had put forward was a mirror image of it, which the claimants called the sleeve transactions. And we can show that in our overall chart. The sleeve transactions appear. And they did exactly what we deduced they did, namely, they permitted 2014-1 to finance Q1's transactions, and in exchange, 2014-1 took title to the underlying commodities. And we know that now even for sure, because belatedly, we have the agreement between Q1 and 2014-1 governing these transactions, which we refer to as the VM-MCTA. We put that on the chart. Now, the tribunal might sensibly ask itself, what is the point of Q1 entering into all of these transactions and then immediately transferring these transactions to another company, 2014-1? Well, as Mr. Travers explained in his first report, the attraction of that kind of structure might be that it left no need for Q1 to apply any of its own cash to any of the repo transactions. We've put that excerpt from Mr. Travers' report on slide 75. In the same way as entering into a repo transaction assisted with Samir's cash flow, it seems to us likely that Q1 derived both a balance sheet benefit from entering into the back-to-back repo transactions, the sleeve, as they're called, the 2014-1, and it seems to have also, interestingly, structured the transactions so as to enable it to skim off some of the profit associated with each repo transaction before passing the transaction on to 2014-1. Now, why does that matter? Well, it matters because, as we've already seen, the claimant's jurisdictional case is premised on the commodities underlying the transactions and the contractual rights which are inextricably bound up in the existence and value of those commodities, the put rights. Those are the two assets which they say are their investment. If the claimants never applied their own cash to the acquisition of those commodities and then immediately transferred them pursuant to a pre-existing arrangement with 2014-1 into the ownership of another Cayman entity, 2014-1, which the claimants neither owned nor controlled, then it follows that the claimant's alleged investment was transferred with them. So the structure behind 2014-1 assumed responsibility both for the financing of the transactions and for taking the risk associated with them. It was 2014-1 which issued the letters of credit, pursuant to which the sellers of the commodities were paid. It was 2014-1 which raised the capital underlying the letters of credit, and it was 2014-1 which took title to the commodities. So we have a reality which is at odds with the initial structure we were led to believe was in place. The financing is all coming from an entity and a structure that has nothing to do with the claimants, and the ownership of the underlying commodities is with an entity that's nothing to do with the claimants, along with the risk. And you can see immediately, I hope, why that's relevant to our objections 4 and 1. The claimants played no part in the transactions by which Q1 allegedly acquired the commodities and put rights, and the structure which funded the transactions and took title to the commodities and put rights, the 2014-1 financing structure, had no connection to the claimants. So what do the claimants say in response? Well, they don't deny that the structure and arrangement we've just seen existed. They can't. You've seen the documents. What they now say is that Q1 financed 4 of the 16 transactions which are referred to as Samir 1011, 1014, 1015, and 1016. We've put those on slide 76. We've highlighted them to make clear which ones they now say Q1 financed. Now, pausing there, remember, there is no evidence that any money was actually transferred or used by Q1. And there is a marked difference in this presentation from the claimant's initial presentation to this tribunal that all transactions were financed by the claimants. But in addition to the general evidential problems I've already explained, there's a real doubt as to whether even those 4 transactions were in fact financed by Q1 for the following reasons. First, the claimants accept that 2014-1 issued the letters of credit for each of these transactions. Secondly, Carlyle's only evidence for Q1's participation is a so-called brokerage statement, which is at C61, which they say implies that Q1 transferred some funds to 2014-1 at the time of the issuance of the letter of credit. One example of this, and we've put it on the slide for one of these brokerage statements for Samir 1011, you can see it here. And that is the evidence, the so-called evidence, a ledger entry which states that $10 million was received from Q1 by 2014-1 on the 4th of May 2015. Now, the claimants then require us to go away and look at the date of the relevant letter of credit, which is CO45, page 36, to see that the letter of credit was issued on the 5th of May 2015, so the next day. And then we look down the line to the line labeled 32B, the currency code amount, and we see that it's $10 million. And so that's the basis that the claimants say that Q1 was funding it, that there is a transfer from Q1 to 2014-1 at roughly the right time and in roughly the right amount. But there is no more than correlation linking those 2 transactions. And in particular, and important, there's no evidence before you as to whether 2014-1 retained the funds provided by Q1. It could easily have refunded them a week later for all we know. And there's no evidence as to whether 2014-1 in fact used those funds as opposed to other funds to issue the letters of credit. Thirdly, for 3 of the 4 transactions that they now say were funded by Q1, a sleeve transaction where the title was formally transferred from Q1 to 2014-1 was concluded shortly before the date of the alleged expropriation. So Samir 1011, 1014, and 1015. Now, the claimants haven't produced any documentation in relation to Samir 1016, meaning we don't know when title was passed on to 2014-1 in that case. We know that commodities were transferred as at the date of the sleeve transactions, and the contractual documentation applicable to them contemplates a payment from 2014-1 to Q1. So we can assume that a payment was made by 2014-1 to Q1 as at that date, although again, typically, we don't have any contemporaneous documents provided by the claimants for that. So how can they say that Q1 had made a contribution as at the date of the alleged expropriation? Still less, how can they say that Q1 owned these commodities as at the date of the expropriation? It was their job to produce this evidence. Now, taking a step back, what the tribunal sees is a constantly shifting case. Again and again, the claimants reframe their case as we identify the impossibility or untruth in what you're told. Yet after 4 written submissions, Carlyle's case remains riddled with fundamental jurisdictional problems. And those problems and many more have been forensically dissected by Mr. Deguiar in Vassant's expert report, where he raised significant doubts as to the validity of the transactions between Q1 and Samir. That's paragraph 21C of Vassant's report for your record. And we put out the essence of what he means here. And it's really that the actual functioning of the deal didn't follow the terms of the agreement at all. And they also highlighted the substantial information gaps that remain, as has Mr. Travers, and we've put those on the next two slides. And as I said earlier, they haven't been called, and you will understand why that is. So where does it leave us? 3 points. First, there is a manifest and, in my submission, decisive lack of evidence that any claimant entity other than CCM made any sort of contribution to acquiring these assets. And there is a complete lack of evidence that any of them made a financial contribution. Secondly, the evidence on the record suggests that all or substantially all of the risk associated with these transactions was borne by 2014-1, not any of the claimant entities. It provided all of the letters of credit. It took title to the underlying commodities. Thirdly, title to the alleged investments was transferred to 2014-1. That's not in dispute. And the put rights were also held by 2014-1. That's the other investment. So all in all, it's a bit difficult to see what the claimant's case is on contribution, risk, and investment more generally. And certainly, whatever case it is, it's not supported by any evidence that you could accept. And so in those circumstances, we say you cannot be satisfied that the claimants either actively made an investment or that they contributed to or took any risk in respect of that investment. And that has significant implications for the tribunal's decision, jurisdiction, ratione personae. I'll take this relatively quickly. Insofar as the requirement that an investment be actively made, we explained in our memorial and reply, that requirement derives from the positive language of the definition of investor of a party in Article 1027 of the FTA, which we can bring up on the screen. It's this language that it's an investor who concretely attempts to make, is making, or has made an investment. And we've set out in our briefs, and the tribunal will be familiar with the plain and ordinary meaning of the word make, or made, and the fact that this is emphasized in this definition. And we also referred to the famous analysis of the Standard Chartered Bank in Tanzania, Tribunal RL 18, and we've put paragraph 222 of that on the next slide. But in the interest of time, I'll move through that. Now, unlike the treaty, the only point to note is that unlike the treaty in the Standard Chartered Bank in Tanzania case, the word made, make, or is making is in our treaty, which it wasn't in their treaty. And the definition of investor of a party is couched solely in those terms in our treaty. And by including those words, in my submission, the parties indicated that it wasn't enough for a putative investor to merely be the passive beneficiary of others' investment activities. To be an investor, one must have a role in bringing the investment about. And that requirement is mirrored to a certain extent by the other part of this, the other part of the definition of FTA, Article 1027, that of investment. And that definition, we can bring it up on the screen, provides that an investment must have the characteristics of an investment, and then goes on to say that those characteristics include commitment of capital and other resources, expectation of gain or profit, assumption of risk. Now, we've dealt with this at some length in the memorials. It makes explicit what is implicit in Article 25 of the ICSID Convention, the so-called Cellini criteria. Now, there's been some debate between the Kingdom and Professor Schroer as to whether the Cellini criteria constitute per se a set of prerequisites or whatever, whether they're just suggestions of what investment might look like. But given that FTA Article 1027 expressly conditions the existence of an investment on those characteristics, the debate is somewhat arid. The FTA expressly requires the commitment of capital or other resource and the assumption of risk by an investor if they are to be considered to hold an investment. Now, we say, obviously, in addition, that the characteristics of an investment referred to in FTA Article 1027 must include duration. And it's right to say that Professor Schroer fairly conceded in his second report at paragraph 23 that that is a distinguishing feature to delimit a protected investment from an unprotected sale under the Cellini criteria. We've got that excerpted on the next slide. And that duration point, recall, is also emphasized by the definition of investment in Article 10.27, which we looked at earlier. We'll bring it up on the screen. And it's that footnote 9 again, that short-term financings are unlikely to be considered investments. So duration is expressly in the minds of the treaty parties. And as I've already shown you, the claimant's alleged investment operation was characterized by an absence of any of those criteria, any of those elements. The claimants were entirely inactive in the investment process, even on the claimant's own case, playing no active role in the making of the investments, contributing no capital or other resources. None of the claimants took any investment risk. Rather, third-party investors did, 2014-1 and its note holders. They were expected to carry the can, and the claimants took great care to design a structure which forced that assignment of risk to take place. And finally, at the heart of the claimant's alleged investment operation is a series of short-term financings that lacked sufficient duration to be considered investments under the FTA in and of themselves. So we say that the tribunal should decline jurisdiction ratione personae over this case on that ground. Now, moving to, finally, objection 2. I'd like to spend a little bit of time looking at the ownership and control of an investment in the territory of Morocco. Now, I've already touched on some of the elements, and one factual element in particular, but one factual element is particularly important here, namely that the sleeve transactions required that the commodities be transferred onwards to 2014-1. That alone rather suggests that the underlying investments were sold on by Q1 to 2014-1 as soon as they were acquired. And as we've seen, 2014-1 raised funds in order to finance those transactions by issuing notes. Now, importantly, those notes were issued pursuant to an indenture deed, which is CZ0050, a document signed between 2014-1 and the trustee for the notes, State Street Bank and Trust Company. And we bring that up on the slide, please, and the animation. Now, that indenture deed was a document which the claimants only disclosed with their counter memorial on jurisdiction. Again, it was only after we pointed out their failure to provide it that they produced it, and again buried it away in a footnote, footnote 83 if you want to know. Now, I won't have time to take you through the indenture in detail, but it's a very interesting document, and we've dealt with it in a bit more detail in our reply and in Mr. Travers' supplemental expert report. An indenture, as the tribunal knows, is essentially a document setting up a trust. And here, the State Street Bank and Trust Company was being set up as a trustee of the third-party investors who bought the notes in 2014-1. And crucially, what the indenture did was to require 2014-1 to transfer to State Street Bank and Trust Company as trustee for the note holders all of the title in all the transactions and commodities. And you can see that clause 1 of the indenture on page 9, which we'll bring up on the slide now. So 2014-1 had to transfer all the legal title to any of the commodities to State Street Bank immediately, and State Street Bank held them on trust for the note holders who were not claimants. And we can see that in our animation now. So that the proprietary interest moves in the blue line. That means not only did title to the commodities move to 2014-1 pursuant to the terms of the sleeve transactions, but it moved again to the State Street Bank and Trust Company pursuant to the indenture. Now, quite how the claimants can say that the commodities were owned or controlled by the claimants in August 2015 under this structure is a mystery. Indeed, we are light years away from the inaccurate presentation made in the memorial, namely that the commodities stored in Samir's tanks were owned by claimants. Paragraph 27 of the memorial. Put it on the next slide. You can see it. That's just not true. Now, as if the claimant's position wasn't sufficiently problematic by what I've shown you so far in the documents, I'm afraid to say that the factual reality of the transactions makes matters even worse. The entire transaction structure I've just described to you has recently been found by the New York courts, in effect, to be a sham. And what the New York courts found is consonant with what we surmised, namely that, as I said a little earlier, this entire structure was a fig leaf concealing a very different reality. In reality, Q1 and 2014-1 knew very well that as soon as Samir received the oil, it refined it and it sold it into the market. And they accepted that. It didn't keep it in its tanks for Q1, for 2014-1, or for anybody else. And it did that for the obvious reason that it needed to refine it and sell it in order to pay Q1 and 2014-1 what they were due. If we bring up on the screen R0006, this is what the Supreme Court of the State of New York concluded about the way these repo transactions proceeded in reality. Paragraphs 5 and 9 of the judgment. In practice, Samir processed the oil and sold the resulting refined products on an ongoing basis without either payment to Carlyle or prior written consent, and then paid Carlyle after some period of time. Number 9, paragraph 9. Samir did not steal the oil by refining it in the ordinary course of its refining operations. Carlyle's losses were not due to theft by Samir, because Samir and Carlyle had an ongoing business relationship, and Carlyle expected that the oil it purchased and that was delivered to Samir would be used in the refining process and eventually paid for, usually after the time for payment provided in the MCTA. So the parties on the Carlyle side, who were involved in this, CCM, entered into a course of conduct in which Samir purchased, refined and sold the oil and then paid Carlyle back. And as the New York court put it, the structure set out in the contracts was simply not what occurred in the real world. If we ever had to get into the merits of this case and we were to get to document production, it could well be that what becomes clear is that this was a really troubling situation, a really troubling structure, and that things happened and the way that this structure was run was really very problematic. Now, I need to just go quickly back into protected information, I'm afraid, for one final time. Now, what this means for your jurisdiction is clear. It means that while on paper, there may have been some suggestion that there were physical commodities being held in storage and that title was going to be transferred between different companies. In reality, those commodities had long since been refined and sold by Samir, and that was done with Carlyle's knowledge and at least its acquiescence. Those transfers of title were just paper exercises. And indeed, the tribunal doesn't only have the New York Supreme Court's finding to that effect, it also has a judgment of the Casablanca Court of Commerce of the 13th of February 2017. And the English translation is at R004. I'm not going to take you through it all in view of the time, but the conclusion of the court, which we've exerted on the slide here on the screen, was that Samir was not the consignor of petroleum products belonging to Q1 or 2014-1. They were merely creditors. Now, we made all those points clearly and unambiguously in our reply. The claimants had an opportunity in their rejoinder to challenge what we say, to show that we're wrong, and they failed. They started, because they had to, by admitting that Samir had refined Carlyle's oil prior to August 2015. But they say that that was without the claimant's consent. They then suggest that notwithstanding that some indeterminate quality of, quotes, their commodities, they say remained in the tanks, relying on a tank report from Samir dated the 9th of August 2015. And that alleged report that allegedly shows the claimant's oil in the tank is at CZ62. Starts at page 4 and runs to page 8. We'll put it on the slide. I don't have time to take you through it in detail, but if you look at it in your own time, what you'll see is that it says nothing about Carlyle's oil at all. It's simply a tank report supposedly showing the commodities held by Samir without any reference to Carlyle. And it's striking that that's the totality of the so-called evidence relied on by the claimants to attempt to satisfy you that the commodities were held by Samir for Q1 or 2014-1 as at the 7th of August 2015. If the ownership of the commodities had been such an important element of the transactions for the claimants, one would expect a good deal more paperwork than that, reflecting the commodities and their status, a good deal more focus in terms of the setup and supervision and control by the claimants to ensure that their property was being preserved separately, but there's not. And on that basis, we say that the weight of the evidence taken in the context of the New York Supreme Court's judgment militates strongly in favor of a finding that the commodities which were the subject of the repo transactions had ceased to exist soon after they were purchased. And the implications of that for your jurisdiction are obvious. You can't accept jurisdiction on the basis of any argument premised on ownership and control of commodities which didn't exist. They were no longer extant investments. They'd been refined and turned into something different. The proprietary interest in them, the title to them, such as it was, held by 2014-1 in any event, had ceased to exist. As both the New York Supreme Court and the Casablanca Commercial Court have found, the relationship between Q1 and 2014-1 and Samir was simply one of creditor and debtor. Now, neither, we say, can you accept jurisdiction on the basis of any alleged control of the commodities. And you'll have seen that there's been a lot of engagement on that point. And it's not surprising that the claimants feel so strongly about this control point, because they are aware of all the other problems that I've already outlined to you. And they say they've got this silver bullet that solves the whole problem, CCM. And their case is that CCM was the company which entered into an investment management agreement with both 2014-1 and Q1, whereby CCM was entrusted with managing all of the investments on a discretionary basis. And we've put CCM into the diagram. And the claimants say that in practice, through those management contracts, through the contractual rights, and also through the fact that the employees of CCM essentially put in place whole structures, including being involved in the incorporation of 2014-1 and Q1, they say CCM controlled all the contracts and commodities. And on the basis of that supposed control, the claimants say that this tribunal has jurisdiction over the entire claim. In other words, on the claimant's case, it doesn't matter that the claimants didn't own the oil, directly or indirectly. It doesn't matter that the claimants might not have entered into the contracts. It doesn't matter that the claimants provided no finance and took no risk. It doesn't even matter that this was all a sham. Rather, if they can show that one of their companies had a contractual right under an investment management agreement to direct the actions of Q1 and 2014-1, this tribunal has jurisdiction. Now, I won't take you through all the management contracts in detail because they provide for fundamentally similar relationships, and you have our detailed submissions on them already in our memorial on jurisdiction, paragraph 75. But the point that comes out of them all is that CCM was a provider of professional services to these companies. Much like Carlyle's lawyers, CCM was contracted by Q1, 2014-1, the onshore feeder, whoever, to provide them with what we call professional services, in this case, managing their investments. Some of the relevant provisions of the investment management contracts between CCM and Q1 are set out on the next slide. Now, as you'll recall from the beginning of my presentation, managing investments is what Carlyle Group does. It doesn't do proprietary investment, doesn't take the risk with its own money, just puts in place structures. And those other people who it puts in place the structures for are the investors. And they're the ones who put the money in and take the risk. Using the Carlyle Group is a bit like delegating the investment of your pension to a stockbroker. You might choose which stocks to pick, but it's still your money. You still own the stocks. The broker simply takes a commission based on the contract with you. He's not the investor. And as I will explain, this type of contractual asset management structure falls far short of what control entails under the FTA. So let me now turn to that in terms of the law. I'm not going to address you on the point about in the territory. You have our submissions on that in our brief at reply section 4A, and there's nothing to add following the claimant's rejoinder. It's about title and the applicable law. But with respect to ownership and control, can we go back to Article 1027 of the FTA and the definition of investment? And if we look at the chapeau of that provision, we see the following. Investment means every asset that an investor owns or controls. So in order to qualify as an investment under the FTA, the asset said to constitute the investment must be owned or controlled, directly or indirectly, by the investor. So in this case, one or more of the claimants. Now, turning to the first question of who owns the asset, that's a question of who has title to it. Question of property law, to which international law has no answer. And in such cases, the question of title to an asset, and indeed the existence of the asset itself, must be decided by reference to domestic law. And we've put on the next slide the well-known explanation of the EMIS tribunal making that point good, that you have to look to host state law to establish these sort of proprietary rights. And it went on then to say 175 and 176, which we've added to the bottom of the slide, that the tribunal has to try and determine the content of domestic law. And it refers particularly to decisions of municipal courts, whilst not dispositive as being obviously important. So it follows that when you consider one of the central questions in this case, who owned the commodities that remained, any commodities that remain in Samir's tanks as at the 7th of August 2015, you have to give great weight in my submission to the verdict of the Casablanca court on the subject, as Morocco is the situs of the commodities. And we know, we just looked at what the Moroccan court said about that. They said that the commodities belonged to Samir, not to Q1 or 2014-1 or any claimant entity. They were just debtors. But even if, as a matter of Moroccan law, Q1 and 2014-1 could be deemed to own the commodities in the first instance, title to the commodities didn't rest there, but was passed to State Street trustee, as we looked at before, to be held on trust for the note holders. And the claimants admit that in paragraph 64 of their rejoinder. So that's another basis on which we say the claimants cannot have owned the commodities directly or indirectly, albeit one that doesn't rest on Moroccan law, but on the undisputed effect of the contractual transactions. So on that basis, none of the claimants can be said under FTA Article 1027 to own the commodities. That also has implications for the concept of control, which I'll come on to in a moment. But for now, with the exception of CCM, the claimant's case that they control the commodities arises through their indirect ownership and therefore control of Q1. So if Q1 didn't have title to the commodities and therefore owned them, it follows that the claimants couldn't control them. Now, turning to CCM and the concept of control and the definition of investment, as the tribunal's aware, there's a significant disagreement between us about this. And that's relevant because the claimants say that even if none of the claimants owned any of the commodities for the purposes of Article 1027, CCM still controlled them, so CCM still has an investment. And TC Group and Carlyle Group are also claimed to have had control through CCM, but so we can focus on CCM, because if CCM didn't control them, then it's a derivative point and it doesn't help. Now, if CCM doesn't control the assets as it claims, it doesn't hold any investment and cannot be an investor. It's not alleged that CCM owned any investment, and so the tribunal will lack jurisdiction over CCM, and its claims would need to be excluded if it doesn't control. Now, the basis of CCM's control of Q1 and 2014-1 is not in any way rooted in an allegation of ownership of Q1 or 2014-1. Doesn't own any part of them, it's not alleged to. It is not a legal control, but entirely a de facto control. And that control is said to derive through these management agreements, which are said to enable it to control the assets of the companies. Now, the concept of de facto control has been described in the NAFTA case law, and principally Thunderbird and BMEX, and the claimants have relied on both of those cases and introduced them into the record. But when one actually considers the jurisprudence a bit more closely, it's clear that the concept of control for the purposes of the FTA is dependent on some level of proprietary interest in the company or asset in question. And the BMEX tribunal set this out relatively clearly, and we can put that up on the slide, please. This is in the context of control as it appears in NAFTA Article 1117. The interpretation of own also gives meaning to or control in Article 117. And so control can mean the legal capacity control and de facto control. And then it sets out the three things. Owns all the extant shares, an enterprise that the investor owns effectively a sufficient number of shares to confer the legal capacity to control an exercise that the enterprise the investor controls, or does not own a number of shares sufficient to confer the legal capacity to control, but is otherwise able to exercise de facto control, also an enterprise that the investor controls. So from this, it's clear the BMEX tribunal saw the idea of control under NAFTA as dependent on some form of proprietary interest in the thing said to be controlled. In all three elements, there is some form of qualifying proprietary influence. In the first, you have 100% ownership, so that the investor owns the company. And according to the BMEX Tribunal, anything less than 100% proprietary interest isn't ownership. The second paragraph, paragraph B, that is effectively holding of whatever the majority of the proprietary interest is, assuming all other things are equal, which is sufficient to allow control over the company in the usual way, and that's de jure control. Paragraph C is holding a minority proprietary interest in the company that is insufficient for legal control, but nevertheless coexisting with an ability to exercise control through other means. For example, you might have a minority shareholding, but under the shareholders' agreement, you have control. That is de facto control, and that's what we're concerned with here. But as we see, even in paragraph C, the BMEX Tribunal clearly saw control as being predicated on at least a minority proprietary stake. And that is because, as a matter of commercial and common sense, in order to truly control something, that control must not be bestowed by a contractual revocable means. You have to have a proprietary stake in the asset, be it direct or indirect. And where the asset in question is held by another company, the entity asserting control must demonstrate a proprietary interest in that company to demonstrate control. Now, if Carlyle were correct, and control of some aspects of an entity's decision-making via a contractual power can convey control of the entity and its assets for the purposes of the treaty, it would lead to perverse and absurd outcomes, granting standing to an investor as investor to entities that are clearly anything but. To give a simple example, if the claimants are right, then if you have a company incorporated in Morocco by Moroccan nationals using Moroccan capital, and it appointed a US CEO pursuant to a contract granting him or her power to decide on the allocation of the company's resources, then that Moroccan company would be deemed to be an investment of the CEO, and he would be entitled to bring proceedings against Morocco under the FTA. It's self-evidently absurd. It's unreal to say that the CEO of a company is an investor in the relevant sense in the company or its assets merely because he has certain delegated control powers granted by its true owners under a contract of employment. Precisely that point was raised in Aguas de Tunare and Bolivia, RL 89, a case in which the tribunal, as you will know, was required to interpret treaty language by which national of a contracting party was said to include legal persons controlled directly or indirectly by nationals of that contracting party. And we've put this quote up on the slide, and I'll move on from it in the interest of time. But the key point we've highlighted, it's not intended as an alternative to ownership, since control without an ownership interest would define a group of entities not necessarily possessing an interest, which could be the subject of a claim. Control indicates a quality of the ownership interest. Now, if you're against me on this point, and you accept that de facto control for the purposes of FTA Article 27 and the definition of investment can be established in the absence of any proprietary interest, then CCM needs to prove to you that that control exists as a matter of fact. And the first point to think about there is that in both Thunderbird and BMEX, the respective tribunals acknowledge that any investor attempting to establish jurisdiction on the basis of de facto control is subject to an enhanced burden of proof. And you can see that on the next slide, that we put the quote from the BMEX Tribunal, presents a greater evidentiary challenge, and the Thunderbird Tribunal went further, and you can see the BMEX Tribunal quoted the Thunderbird Tribunal, the absence of legal control. The tribunal is of the opinion that de facto control must be established beyond any reasonable doubt. And as I've already described, CCM can't even meet a lesser burden, still not that. Now, you have our submissions on what the terms of the management contracts are, and you have the expert evidence, which you may wish to discuss with Mr. Taylor in due course as to the way control is approached in accounting. And as he explains in his report, under both IFRS and US GAAP, control is established where there is something more than just a contractual delegation of rights. The question, in layman's terms, is whether a company is acting as principal or agent broadly. If it's the former, if it's acting as principal, then it controls. If the latter, it doesn't. And we've put the relevant standards on the next two slides, which we can perhaps skip through, as I know I'm almost out of time. So to wrap up, it follows that CCM cannot possibly be said to control Q1 or 2014-1 or 2015-1. It was simply a professional services provider with contractually delegated powers. As we've seen, that is not enough for it to qualify as an investor. And as to the other 5 claimants, remaining claimants, as I've said, their case is also hopeless jurisdictionally because there's no evidence that they made any contribution at all to these transactions, and because they were entirely passive companies up the corporate train from the transaction. They didn't make the investment or contribute anything to it. But more importantly, and before you get to any of that, you don't have any jurisdiction over any of the claims because they're all in respect of losses, which on the claimant's own case were indirect. And that puts the claimants firmly outside FTA Article 1015(1)(a), as both treaty parties have confirmed to you. Unless I can assist you further, those are my submissions.
Thank you very much, Mr. Harris. Let us get a time check from the, Madam Secretary.
2 hours, 2 minutes, and 26 seconds.
So you were very much spot on, but we will give also to claimant 2, 3, and even 5 minutes more if you need them, Mr. Ordway. But before we do that, we have to break, and it is now 16:55 in Europe, and we will come back at 17:15 in 20 minutes. 17:15 Spanish time, and so whatever it is in the United States. I don't dare to make the calculation. Very good. So we are back 17:15. Thank you. Very good. So we resume the hearing and we give the floor to claimant and to Mr. Ordway.
Thank you, Mr. President, co-arbitrators. The presentation that this tribunal just heard from Respondent Counsel this morning, your afternoon, in many ways mirrored Morocco's written submissions insofar as it contained numerous misstatements of fact and law. Indeed, it is Morocco's counsel position that it is claimants that have made the misstatements. And again, I really feel strongly about this, and that is that as our submissions have shown, it is Morocco that has made the misstatements. In any event, I will address those over the next 2 hours. But I will also note that that Morocco has in fact digressed significantly into various tangential matters that really go far beyond the scope of a jurisdictional inquiry. Now, jurisdictional analysis can certainly be complex, particularly when the underlying investment is complex, as is the case here. But this is not a merits hearing, and that is critical because in large respects, I believe that Respondents' Counsel seeks to make this a merits hearing and not a jurisdictional one, but it is not. This is a jurisdictional hearing. And I believe that once we have addressed some of the misrepresentations, overstatements, omissions of fact and law, that the issue of claimants' standing and right to jurisdiction in this case becomes far more straightforward than Morocco's counsel has portrayed it to be. Certainly the tribunal should not be swayed by the sheer multiplicity of counsel's arguments, nor should it be impressed by counsel's ability to read Morocco's desired meanings and propositions into cases where they simply aren't there. But what claimants would ask that the tribunal do is keep the following 2 very simple overarching points in mind during my presentation. For Morocco, a finding of no jurisdiction would allow it to fully escape responsibility for its wrongful actions against claimants' investments in Morocco, without even delving into, much less having to justify those actions on the merits. As you no doubt heard, counsel's representation would have you believe that a few Cayman entities, out of their own volition and with no relationship to the claimants, or very little relationship to the claimants, made the advancements at issue and sought out, or implicitly, claimant Carlyle Commodity Management, it's been referred to as CCM, merely to manage their money. However, Morocco itself has acknowledged that the entity dealing with Samir was CCM, and we will show you a document that expressly reflects that. At the time, CCN was known as Vermilion Asset Management, and the document that we will show you expressly acknowledges that, that CCM, then VAM, was the entity that was dealing with Samir. And it is indisputable that the Cayman investment vehicles that Morocco has sought to emphasize so much had no employees. And this is a critical fact. We are not talking about active companies in the strict sense. These entities had no employees and were completely controlled in every respect by claimants, and by CCM in particular, as claimants are the only entities that have any rights to pursue their claims in this arbitration. Morocco will have no further risk of liability under the FTA to anyone else should jurisdiction be denied to claimants. And again, this is important. It's for this reason we believe that Morocco has taken such a scattershot approach in these proceedings, in the hopes that the more it throws against the wall, the greater the possibility that some of it will stick. Now, Morocco's aim is to convince the tribunal to focus on minute points that may sound significant at first blush, but are in fact wholly irrelevant to the jurisdictional analysis. In essence, Morocco is asking the tribunal to prejudge the case on half-truths and sometimes blatant untruths. For claimants, by contrast, upholding jurisdiction will simply allow them to present their merits case and seek to obtain the justice that they've been pursuing for years, and to recover for hundreds of millions of dollars in losses. And these are losses that were, contrary to what Morocco says, sustained by claimants. And it is true that the Carlyle entities have tried to seek recovery in the Moroccan courts, but to no avail. And we vigorously dispute the conclusions that Morocco's counsel has cited in terms of the rights that claimants had to the commodities at issue. And as to the New York insurance litigation that has been referenced by Morocco's counsel, that is an unrelated insurance matter that has nothing to do with this holding, and is, by the way, on appeal. So for purposes of this week's hearing, we simply ask that we be granted the opportunity to have our case heard, because jurisdiction certainly exists here, and we will demonstrate that. Now, before we address the specific objections that were lodged by Morocco, I'd like to first go over the investments in Morocco that are the subject of this case, and clear up certain facts about these. First, let's just take a look at the actual claimants. I know there's a diagram that has been presented. We also have a diagram that we have prepared.
So this, Mr. Ordway, this should be now H2. This presentation is document H2. Let's give it a number.
All right, very good.
That is agreeable to you.
Absolutely. So as set forth in slide 1 of H2, the claimants are the following 6 related U.S. entities: the Carlyle Group LP, Celadon Commodities Fund LP, which we have referred to as the U.S. onshore feeder, Carlyle Commodities Management LLC, which we have referred to as CCM, Celadon Partners LLC, TC Group LLC, otherwise referred to as TC Group, and TC Group Investment Holdings. In 2015, claimants engaged in a series of complex commodities transactions with Samir, the owner and operator of Morocco's refinery at the time. 16 of these transactions remain still open and unpaid as of today, and the transactions involved, among other things, the storage of hundreds of thousands of metric tons of crude oil and refined products in tanks at Samir's refinery in Morocco, which claimants came to acquire and own pursuant to certain agreements between the parties. Now, Morocco's counsel has raised certain issues about title. We will address those, and we obviously dispute their conclusions in this regard. Moving to the next slide, claimants' investment is, just to be clear, it is the crude oil and refined products that they acquired and owned, and the accompanying proceeds from any sale of those commodities, and the related contract rights, including the put rights tied to those commodities, and the right to recover proceeds from the sales of those commodities. This arbitration, of course, concerns claimants' loss of those assets due to Morocco's wrongful actions. Now, the entire investment was conceived, set up, and run by one of the claimants, Carlyle Commodities Management LLC, or CCM, and it was done from its offices in New York in the United States. In doing so, CCM raised capital through a series of investment vehicles which CCM created. These vehicles, which Morocco has sought to enhance in importance, these 3 investment vehicles from the Caymans, VMFQ1, 2014-1, and 2015-1, these entities had no employees whatsoever of their own. I will address the exact corporate structure of these entities and how they relate to one another, as I've said, a little later. But suffice it to say at the outset that CCM was undoubtedly calling the shots in making all decisions with regard to the investments. It set up all of the entities involved in the investments. It traded the commodities. It engaged in hedging transactions. It arranged for the transportation and storage of the commodities. And again, this is something that Morocco itself, in the letter that we will show you from the Bureau d'Échange, it was recognized by Morocco that it was CCM that was the appropriate party dealing with this. And it signed all necessary documents on behalf of the investment vehicles that it set up to facilitate the investment transactions. Now, how did they work in practice? Okay, as set out in our papers, they were governed by a master commodities transaction agreement, which we've referred to as the MCTA, and a commodities storage agreement, the CSA, and a series of individual transaction confirmations. Now, while the mechanics were complex, the key points for this proceeding are that claimants, through their investment vehicles, obtained title to both crude oil and refined products that were to be stored in Samir's tanks. And claimants also held a put right, a contractual put right, which allowed them, but critically did not obligate them to resell the commodities to Samir at a fixed price plus a premium at a later date within an exercise period. Again, Morocco was well aware of the arrangements here. Indeed, the Office d'Échange in this letter that you see before you, expressly approved of this arrangement in January 2015, acknowledging that Samir was entering into an agreement, and you see it before you, with the US company Vermilion Asset Management. And that Samir was to, and again, here's another very critical part of the document, that it was to transferring ownership of the commodities to CCM. Now, as things stood in early 2015, claimants and Samir both fully expected that theirs was a long-term relationship. And this goes obviously to the duration point that we'll come to shortly. And that duration, that commitment was for a 3-year period. As you see, it says the minimum amount of the commitment until at least June the 30th, 2018. However, as we have seen, and you know from claimants' submissions, beginning in August 2015, 6 months into the arrangement, the Moroccan government did the following. It froze Samir's bank accounts, seized control of the refinery operations, swept funds from Samir's bank accounts that were earmarked for Carlyle, directed Samir to sell claimants' commodities into the open market, arranged to collect the proceeds from such unauthorized sales, and prevented claimants from ever receiving any of the proceeds from the unauthorized sales. Obviously, this is not something that Morocco's counsel focused on, but these are the acts that precipitated this arbitration, and they're important. Now, Morocco insists that these investment transactions were mere repo transactions, and we heard that again in the presentation today, involving credit-based financing, and the claimant's interest in the commodities was limited to profiting from extending lines of credit to Samir. The investment agreements and the record, however, conclusively dispel those notions. As you will see, the MCTA is very clear that the investment transactions were true sales of the commodities, and that each transaction was an absolute transfer of the entire legal and beneficial interest in such commodity, and would not be a transfer as security for a loan. In other words, claimants had a clear vested ownership interest in the commodities. In fact, that was a fundamental aspect of the agreement. Now, I would like we're going to go briefly into confidential material, if we could, please.
Yes, we will move the non-parties into the waiting room.
Thank you. Thank you. As I've already mentioned, the MCTA also provided claimants with a put right that gave claimants all important flexibility and optionality. And again, this too is not typical of a standard repo transaction under which the counterparty has an obligation. Indeed, as claimant's expert Rory Walk has testified and will testify during this hearing, what was present in claimant's transactions but is not present in typical repo financing includes claimant's ownership of the assets, not collateral for a loan, claimant's put rights, and claimant's need for a storage agreement and insurance to protect against the loss of the commodities. The relationship between claimants and Samir was also a series of multiple transactions over a period of time, as we've noted, intended to be at least 3 years. Now, on the other hand, a simple repurchase agreement, which is what Morocco's counsel seeks to have you think this was, such an agreement used in the securities and banking world typically functions as a vehicle for overnight lending among banks, securities dealers, and the Federal Reserve. It uses a standardized agreement, designates English law for international agreements, and involves an auction process to set prices, none of which was the case for claimants' transactions with Samir. All of these components have led Mr. Walk to conclude that claimants' transactions with Samir were clearly complex, hedged commodity and derivative transactions and not simple repurchase agreements. And by the way, Mr. Harris referred to options being included in repo agreements, but the Camorra chart that has been referenced by Morocco, it doesn't basically say that the option is an identifying characteristic of a repurchase agreement, and it is not. And so that is really a confusing statement, and it's a mischaracterization. That said, however one chooses to refer to what is at issue here, it is the main issue is whether the transactions qualify as an investment under the treaty. And as we have demonstrated in our submissions, and as we will demonstrate further today, they surely do. As another matter, the agreements are unequivocal that Samir was not permitted to use or dispose of the commodities without claimant's express consent and corresponding payment for the commodities. Earlier during the presentation, you heard Mr. Harris said that this was with the knowledge and consent of claimants. That is not correct, and I think the record shows that there was no consent, and you will hear that expressly when you hear Mr. Zuick testify tomorrow. The CSA plainly states that the custodian, meaning Samir, shall not use the commodities absent prior written consent. As I said, you will hear unequivocal testimony from counsel's fact witness, Mr. Zuick, the former chief operating officer of CCM, confirming that Carlyle never consented to Samir refining product without payment. Indeed, he has already attested to this in the arbitration. As the chief operating officer of CCM at the time, Mr. Zuick was a key decision maker and was on the ground running this investment. He will also confirm that it is because of Samir's unauthorized refining that claimants entered into the 3 swap transactions, which are among the 16 transactions at issue in this arbitration. And we'll get to that later when we look at the demonstrative that counsel for Morocco put up on the board, indicating wrongly that there was no information provided about those transactions. In fact, there was no information to provide, and they were fully explained precisely because they were swap transactions, but we'll go into that. Mr. Zuick has testified and will further testify about a letter he sent to Samir in September 2015 on behalf of claimants to reiterate that CCM did not authorize disposition of any commodities. And we expressly prohibit, this is what, and do not authorize, speaking of CCM, the future release of any commodities without payment. And that's contained in Exhibit C, CZ0015. This is the precise opposite of what Morocco has said in terms of there being some kind of implied consent. Mere weeks after Mr. Zuick's express objections, Samir admitted that it had breached the MCTA by refining commodities belonging to Carlyle without authorization from or payment to Carlyle. And this was in the agreement that I cited minutes ago, which is the forbearance agreement that Samir signed in October 2015, in which it made clear that its conduct was due to the government's actions. The forbearance agreement also reaffirmed all of the underlying agreements, including the MCTA and CSA, and the rights and obligations therein. And you will see specifically in the forbearance agreement and the slide that's before you that it says the government of the Kingdom of Morocco froze Samir's bank accounts on or about August 7, 2015, which has prevented Samir from withdrawing funds from its bank accounts in the Kingdom of Morocco, and has directly or indirectly and from time to time expropriated commodities as defined in the storage agreement and required Samir to release commodities as defined in the storage agreement from Samir's custodial possession in order to meet the needs of the Kingdom of Morocco. Those are precisely the words of the agreement. But that's not the end of the story. Claimants then registered their objections with Morocco directly in a December 2015 meeting with Moroccan Minister of Economy and Finance, Mohamed Boussaid, in which Mr. Zouik told Morocco in no uncertain terms that the remaining products in Samir's tanks were claimants, that they could not be refined or sold without claimants' consent, and that claimants did not consent, and any further expropriation must stop. In a follow-up letter to Minister Boussaid, Mr. Zouik then confirmed again the commodities had been improperly removed from Samir's tanks and sold without Carlyle's consent and without payment to Carlyle. Unfortunately, Morocco rebuffed claimants and treaties, and Mr. Zouik never heard back. Now, in the face of this crystal clear timeline and record evidence showing claimants objecting to the unauthorized disposal of their commodities every possible way they could, Morocco now claims that claimants provided consent. These arguments are simply incorrect. As you will hear from Mr. Zouik, the parties never varied the terms of the agreement and claimants never consented, let alone in writing, to the disposal of claimants' crude oil prior to payment. Morocco also has argued that none of claimants' commodities were in Samir's tanks on August 7th, 2015. And you've heard a presentation earlier in which that has been reaffirmed. But when Morocco froze Samir's bank accounts and seized control of the refinery, it is very definitely true that there were commodities belonging to Carlyle. First, there is no question that significant amounts of crude oil and refined products were in Samir's tanks in August 2015, as confirmed by contemporaneous weekly tank stock reports that are in the record. And you will see here in this slide evidence of that. The evidence also shows that oil and product remained in Samir's tanks for several months after August 2015, indicating that the unauthorized disposal of claimants' commodities was an ongoing occurrence after Morocco took over Samir's refinery and froze Samir's accounts. Indeed, CCM commissioned Intertek, an independent inspector, to measure the levels of commodities in Samir's tanks. Intertek issued reports in both December 2015 and March 2016, both of which showed that Samir's tanks still held hundreds of thousands of barrels of product many months after August 2015. Regardless, the question of the precise measure of commodities in Samir's tanks as of August 2015 is a damages merits issue, not a jurisdictional one. And here again, this is a major point that we need to reiterate, and that is that to the extent that the focus is on the extent of the damages sustained, that is not an issue that should be addressed in the jurisdictional phase of the case. That is one for the merits phase. Now, with these foundational facts about claimants' investments in mind, I will now turn to Morocco's mischaracterizations of claimants' corporate structure. In the diagram before you on the screen, all of the claimants are identified with green boxes. You've seen a modified version of this diagram from Morocco, and we will deal with those additions. I start with CCM. As I've already noted, CCM controlled every aspect of the investments from its offices in New York City in the United States. Claimant Celadon Partners, which you will see to the right of the green box reflecting CCM, was the general partner of Claimant Celadon Commodities Fund LP, which we refer to as the U.S. onshore feeder. And as such, it is responsible for the management and day-to-day operations of the U.S. onshore feeder. Celadon Partners appointed CCM to control and manage the U.S. onshore feeder's investment. As explained in our papers, the U.S. onshore feeder directly contributed, and this goes to the point with regard to contribution that Morocco's counsel discussed earlier, over $130 million to the investments at issue here. Each of the other claimants, TC Group Investment Holdings, and the Carlyle Group, had indirect ownership interests in and or control of the investments. Now you'll see it in a white box at the bottom to the right of the legend, VMF Special Purpose Vehicle SPC. This is the entity which we refer to as VMFQ1. And yes, VMFQ1 was one of the Cayman Islands investment vehicles that CCM set up and used to effectuate the investment transaction with Samir. And it was through VMFQ1 that the U.S. onshore feeder purchased and owned the commodities. The two other Cayman Islands investment vehicles that Morocco highlighted during its presentation are Carlyle Global Market Strategies Commodities Funding 2014-1, which we've been referring to as 2014-1, and Carlyle Global Market Strategies Commodities Funding 2015-1, which we refer to as 2015-1. You can see them in white boxes on the right of the screen. These were issuers of debt instruments that CCM also formed to secure investment capital in addition to the funds raised by the U.S. onshore feeder. Now, the fact that a few Cayman Islands vehicles were utilized as part of the overall investment structure does not, contrary to what Morocco may say, negate or detract from the U.S. claimant's ownership and or control of the investments, particularly when we take into account a very important principle that's been referenced in our submissions, in Professor Schroer's opinions, and in investment law, and that is the unity of the investment. Each one of the investments was set up by claimant CCM, and pursuant to investment management agreements between CCM and each investment vehicle, CCM was given complete discretion concerning their investment decisions and the authority to exercise all rights with respect to the resulting investments, including taking legal actions to protect them. Now, you saw references to CCM's control. What you did not see is the fact that they had complete discretion in Morocco's presentation, that is. You did not see that they had complete discretion and the authority to exercise all rights. And contrary to Morocco's statements in their submissions, they've characterized these vehicles as orphan entities. They were hardly that. They were all within the Carlyle family, and that's what's important to understand. These were all part of the Carlyle family, and they were all part of a structure that did indeed sustain losses as a result of the government's actions. And again, as to the Cayman entities, they were entities that did not have independent significance separate from CCM. They were mere paper entities with no employees, no offices, and no managerial discretion. Again, Morocco, through its foreign exchange office, the Office d'Échange, was well aware of the fact that CCM was the party facing Samir in the transactions. You've seen that in the document that was shown to you moments ago. What you don't see pictured, however, here in this diagram, and for very good reason, are the two entities that Morocco highlighted in its version of claimant's investment structure, the Maryland State Pension Fund and State Street Bank and Trust Partner. Again, and Morocco's counsel devotes inordinate attention to the Maryland State Pension Fund. With respect to Maryland, which is pictured in their demonstrative, claimants in their written submissions have already refuted Morocco's contention that Maryland was somehow the real economic party, the real owner in interest as it relates to VMFQ's investment as of August 2015. This is totally wrong. The US onshore feeder is itself a claimant, and as will be discussed later in this presentation, the origin of the funds is not relevant as a legal matter. The Maryland actually had a negligible role in anything that happened with respect to the investment. Once Maryland invested the funds in the US onshore feeder, those funds became part of the claimant, US onshore feeder's assets. And as a mere limited partner, Maryland retained no discretion at all to manage the US onshore feeder's assets. Rather, claimant Celadon Partners, the general partner of the US onshore feeder, and CCM were in full and complete charge of the investment. Taking Morocco's position to its logical conclusion, essentially, if we accept what they appear to be saying with regard to the Maryland fund, they would suggest that pensioners living in Maryland rather than claimants are really the proper claimants here. And that is frankly an untenable position. Similarly, Morocco wrongly focused on the role of the notes trustee, State Street. And while it is true that under the terms of the indentures, CCM was obligated to transfer title of the commodities securing the notes to the trustee, the indentures are also unequivocal that any so-called title that the trustee held was on behalf of the note holders and the investment. And moreover, Morocco, what they failed to say is that CCM controlled the commodities at all times and could transfer title to whichever vehicle it wanted. There is nothing about that arrangement that undermines the claimant's standing here. And by the way, with respect to the statement that was made concerning the note holders being foreign investors, again, counsel for Morocco misstated the record. It was very clear from a witness statement submitted by David Johnson that the overwhelming majority of those note holders were US note holders. Again, we do not view this as particularly relevant because, as is clear from the case law, the origin of the funds is irrelevant. However, I merely point this out because it is a mischaracterization. I believe that counsel for Morocco said some were US, some were not US. That is not what was stated. Mr. Johnson said very affirmatively the overwhelming majority were US investors. And again, not that that makes any difference. With respect to burden, and I'd just like to make that perfectly clear, because there has been some issues with respect to burden. Claimants initially had the burden to establish a prima facie case. That is true, but it did so. And the burden has now shifted to Morocco to establish the merit of its objections, which we believe they have failed to do. But respondent now, under the case law, including the PACREM versus El Salvador case that we referenced in our papers, it is Morocco that has that burden. And it has met that burden. Specifically, claimants have provided extensive evidence that, one, contrary to Morocco's objection number 1, the crude oil and the refined products and related contract rights are investments that have the characteristics of a covered investment. 2, contrary to their objection number 2, claimants collectively had ownership interests in and complete control of the investments. Contrary to Morocco's objections numbers 2 and 4, because this is part of both of those objections, the investments were made in the territory of Morocco, which I recognize that respondent did not spend much time on and attention, but we will just affirm in our presentation why that is absolutely true. And then contrary to Morocco's objection number 3, claimants did suffer losses as a result of Morocco's breach of the FTA. Now, it's very important, particularly with respect to certain of the objections made, but in general, that the tribunal's jurisdictional determination must start with the plain language and ordinary meaning of the FTA, which unfortunately Morocco seems to depart from quite frequently. And this is consistent. The notion that you must look to the language, the plain language of the treaty, is consistent with Article 31 of the Vienna Convention on the Law of Treaties, which provides that, quote, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. Moreover, the International Law Commission, which was created by the United Nations to develop international law, and including investment law, international investment law, the ILC has explained that the proper approach to treaty interpretation is that the text of the treaty, quote, must be presumed to be the authentic expression of the intention of the parties and should be favored above any external sources about the parties' intentions. Now, based on Morocco's objections, 3 provisions in the FTA govern the jurisdictional analysis here. First, the definition of investment, which is critical, in Article 1027 of the FTA, and which is at issue in Morocco's first and second objections. Second, the definition of investor of a party, also in Article 1027 of the FTA, which is at issue in Morocco's fourth objections. And finally, Article 1015(1)(a) of the FTA, which is the basis for Morocco's third objection. Let us start with the first objection, which implicates the definition of the term investment. Plain text of the FTA, Article 1027, makes clear the
We are having some, Mr. Ordway, we are having some difficulties with your voice. The image is excellent. Maybe if, I don't know.
I have a microphone.
Yeah, now it's much better. Thank you. Now it's much better. Yeah, sorry to interrupt you, but you were coming.
No, I'm glad you did.
That's much better.
See if I my microphone so that you can hear it better. Okay.
Thank you.
Okay. Again, the plain language of Article 1027 means, it says, investment covers every asset an investor owns or controls directly or indirectly that has the characteristics of an investment, including such characteristics, the commitment of capital or other resources, the expectation of gain or profit, or the assumption of risk. And then forms that an investment may include, and it goes on to list some exemplar categories of investments. And by the way, just going back to that previous slide, what's extremely important is the use of the term, the disjunctive or, which during its submissions, Morocco's counsel has conveniently left out in some instances, is not and controls or and the assumption of risk, but rather or. In any event, let's go to the list, because the list of exemplar categories of investment.
These things happen, and so take your time and restart your argument. I think we were in
Thank you,
the
Mr.
interpretation of the FTA.
We were. Specifically, we were on a slide showing the 1027, the types of exemplars. There we go. Okay. So as we can see, D references future options and other derivatives, which covers claimants' put rights, and H, other tangibles or intangible, movable or immovable properties, which covers claimants' commodities. Now, these categories are not exhaustive. Rather, any asset that has the characteristics of an investment may be covered. The definition is, in short, exceptionally, well, it's quite broad. Now, I'd like to briefly address Morocco's assertions that claimants' transactions were nothing more than a short-term financing. That was an important part, at least Morocco's counsel saw it as an important part of their presentation. But here the investments unequivocally involve transfers of title to the commodities, as we have seen in the prior slides that were shown to the tribunal. They were not collateral for a loan to Samir. And claimants never, of course, conceded that point in their rejoinder. They did make a reference to the fact that were they to be to find that transactions were more akin to loans, they would still qualify as investments under the FTA 1027 under subsection C. But I think there was a misunderstanding there, or at least there was some reference to paragraph Article 12 being applicable, whereas in fact it is not applicable. In any event, we'll return to that. But unlike the types of debts that are not likely to have the characteristics of an investment, such as claims to payment that are immediately due and result from the sale of goods, this was not a one-time transaction in any event. There was nothing about this that would make it a one-time short-term loan. No collateral, multiple transactions, multiple duration intended. So the idea that this was a short-term loan is simply not supported by the facts. It's not supported by the MCTA. It's not supported by the evidence that I identified earlier, the statement that I identified earlier, which was subject to confidentiality, and it was not so indicated either in the forbearance agreement. In any event, let us look at the whole issue of what the characteristics of an investment are. Morocco claims in its first objection that the reference to such characteristics as the commitment of capital or other resources, the expectation of gain or profit, or the assumption of risks, mandates the strict application of the factors identified in the case Salini versus Morocco, the so-called Salini test.
I'm sorry,
as an initial
Mr.
matter.
President, I'm finding it quite hard to hear Mr. Ordway.
No, I don't know who is speaking, but I do hear him very well. Who is speaking?
It's the court reporter. I'm sorry.
Oh, that is very, Diana, that is very important. Okay, maybe I was hearing him well. but maybe you have to speak a little bit up, Mr. Ordway, if you would be kind enough.
Sure. Again, just for the sake of everyone, I shifted from a microphone, one of like this, to the microphone that's on the device. Yes.
So you have to be closer. Eric, you have to be closer to the device.
So I'll have to be closer.
Right.
That's fine.
Okay.
Thank you
Not a
very much.
problem.
Thank you.
Now, Morocco claims in its first objection that the reference to these characteristics has to basically meet the Cellini test. Now, our papers, and they basically argued that claimants do not have standing because they have not met all of the Cellini factors. Our papers address at length the various reasons why the so-called Cellini test is not dispositive. And by the way, we believe we've met all of those factors, but just as a matter of principle, there are several reasons why the Cellini test is not the appropriate, it's really not a test that is supposed to be applied as in the sense of a requirement. But first of all, the plain language of Article 1027 expressly and intentionally uses the disjunctive term or, indicating that a covered investment does not need to have all of the referenced characteristics. Morocco's reading in its submission says that the use of the plural term characteristics somehow trumps the disjunctive or and requires that the investments have more than one of the example characteristics. But that's a tortured reading. All that means is that the investment at issue must have more than one characteristic, which it clearly does. Second, the list of sample characteristics notably excludes duration. It is simply not in the treaty. Third, the clear trend among investment tribunals over the last decade, and we have referenced the cases at issue in both of our submissions on this, but the trend has been that the so-called Cellini test is not a test of requirements. It's not a jurisdictional requirement. Contrary to Morocco's arguments, there is no inherent meaning also in either Article 25, 1 of the Exit Convention, or otherwise outside of the FTA that overrides the plain language of the FTA, Article 1027, and requires claimant to satisfy the so-called Cellini test. As our expert, Professor Christopher Schroyer, has opined, most tribunals that utilize the Cellini criteria, and I will quote him, use them as a convenient checklist that may usefully be applied as a starting point for their analysis. But this is a far cry from accepting them as strict jurisdictional requirements. And for example, in Theodoros Adamakopoulos, the tribunal's decision on jurisdiction issued less than a year ago state that it could, quote, only view the Cellini test as subordinated to the applicable rules and principles of treaty interpretation, in particular the requirement to have regard of the ordinary meaning of the term investment, unquote. It further stated that the so-called Cellini test should be applied holistically in accordance with the international law rules and principles of treaty interpretation and not cumulatively. There are many other cases that say the same or similar. In Philip Morris versus Uruguay, for example, the tribunal unequivocally stated that there is no such a jurisprudence constante with respect to acceptance of the Cellini test, and that the Cellini factors cannot defeat the broad and flexible concept of investment under the Exit Convention to the extent it is not limited by the relevant treaty. However, again, even if the Cellini test were applicable here, there's no question at all that claimants would meet them. But before turning to those factors, there's an important threshold point, and that, again, you've got to consider the unity of the investment in considering all aspects of the treaty here. As Professor Schroyer has stated in his opinions, tribunals have consistently adhered to the view that an investment operation although often composed of a number of discrete transactions and activity, must be treated as an integrated whole. And there is case law that he referenced and that we have cited to this effect in CSOB versus Slovakia, for example. The tribunal articulated the principle as follows: a dispute that is brought before the center must be deemed to arise directly out of an investment, even when it is based on a transaction which, standing alone, would not qualify as an investment under the convention, provided that the particular transaction forms an integral part of an overall operation that qualifies as an investment. And there are many other cases that say the same thing. In Maris Perestroika versus Ukraine is another one. The important point here is that you must take into account the concept of the unity of the investment. Now, as I've noted, in accord with the unity and investment principle, the three Salini factors emphasized by Morocco, commitment of capital, duration, and assumption of risk, have to be evaluated holistically. Claimants, in fact, have committed capital or other resources, including by contributing their own funds, directing funds, or providing management expertise regarding the investments. For example, as Mr. Zulik has explained, the U.S. onshore feeder contributed over $130 million to the investments, over $60 million through letters of credit that it initially funded, and approximately $70 million in crude oil that were swapped for valuable refined products to close out two of the transactions. In each case, CCM, at its sole discretion, directed that the U.S. onshore feeders funds be used to make the investments at issue. Again, it was surprising to hear Morocco continue to argue that there's no evidence that the funds were contributed by the onshore feeder. The record plainly shows the flow of funds as reflected in the audited financial statements of the U.S. onshore feeder. Now, counsel for Morocco attributes importance to the fact that the audited financial statements, which were presented as evidence, are dated December 31st of that year. But Mr. Zuek will testify tomorrow that those funds were contributed before that time, and that the losses that were sustained as a result of the investment, as a result of the contribution. So that will be made extremely clear. And we believe that the audited financial statements should not be discounted in any way, because they do establish the direct flow of funds from the U.S. onshore feeder to the master fund to VMIQ1. And as displayed in the diagram, here it is. These are the amounts: $184 million to the master fund, $157 million from the master fund to Q1, and $136 million to the Samir investments. Now, we do want to make a few points with regard to the demonstrative that was introduced by respondent. Respondent makes it seem as if somehow information was missing or was not provided. Again, there's just nothing that is missing for the bottom line entries, the three entries identified as 14, 15, and 16. Okay, the Samir distillates, fuel oil, and gasoline deals. No information on letters of credit was provided, precisely because, as claimants have explained in their rejoinder, these transactions were not funded by letters of credit. So there was nothing missing in any way. For these deals, CCM traded $76.9 million of crude oil owned by VMFQ and indirectly owned by the U.S. onshore feeder for an equivalent value of refined products. Therefore, the claim that information was missing is simply not correct. Likewise, for the distillates, gasoline, and fuel oil deals,
noted on respondents Charles, no information on sleeves was provided because VMFQ1 did not sleeve title to the commodities onward. In any event, that is just with respect to that demonstrative. What should be clear is that in directing the funds into the investment, CCM contributed the commodities themselves when they exercised the put rights. And CCM contributed also, which is really not mentioned at all, or very little way, by Morocco's council, its vast investment management expertise. As Mr. Zouik has indicated in his witness statements, investors in the investment vehicles understood that their returns were based solely on the decisions of CCM, and CCM expressly advertised the expertise of the principal employees of the company who were charged with making the investment decisions. And as noted in the 2014 offering memorandum, Mr. Zouik owned extensive experience prior to his position as CCM's COO, including his work as the Chief Financial Officer and Chief Administrative Officer for Lycra Capital and Starview Capital Management, among other notable positions. Now, Morocco has argued that each claimant must have either directly contributed its own funds or directed funds to the investments to have standing. That argument, however, runs counter to well-established international law. In Saipem versus Bangladesh, a case that was cited in our prior submissions, the tribunal rejected Bangladesh's argument that because claimant never, quote, actually put its own money into the project, unquote, no protectable investment existed. As the tribunal succinctly put it, the origin of the funds is irrelevant. Similarly, the tribunal in Teimber versus Argentina also held that the origin of the funds was irrelevant, so long as the funds were in fact contributed by the investor. And by the way, this principle, which is found in numerous other cases, renders the suggestion in one of Morocco's demonstratives, as I've said before, which shows that the note holders, identifying the note holders as so-called third-party investors. I've made that point previously, just want to reiterate that point, and also that as a factual matter, it is also not correct, as per the witness statement of David Johnson. Now, turning next to the duration factor, as I noted near the outset, claimants and Samir fully intended to engage in a long-term commitment. You saw the evidence of that in the commitment letter, and that it was a commitment that was supposed to last a minimum of 3 years, and it was signed by the parties in June 2015. The case law is very clear that what matters is the intended length of the investment, not the actual length, especially when, as was the case here, the very reason for the truncation in the time period was the sovereign's wrongful actions against the investment. And this is also made clear in the case Mason versus Korea, brought under the US-Korean FTA, which Article 11.28 is virtually identical to Article 10.27 of the FTA. The tribunal in that case held that duration should be determined using a, quote, flexible approach, which takes into account all of the circumstances and the investor's overall commitment. In short, the same holistic approach that we propose the tribunal use here. Observing that the claimant expected the investment in Samsung minority shares to be more of an open-ended long-term investment, the tribunal determined that neither an average holding period of 3 to 9 months nor trading records demonstrating individual buy and sell executions of about 2 months, quote, did not contradict claimant's intention to hold Samsung shares for a longer period of time. As to the risk factor, the facts speak for themselves. Claimants are before the tribunal today having suffered a loss of over $390 million. That alone is evidence that my clients assumed a substantial risk in connection with the investments. But more specifically, claimants undertook several kinds of risk in the investments, including the risk of physically losing their crude oil, the risk that their commodities would decline in value should claimants have been forced to sell the commodities to a party other than Samir. And there was also, of course, a sovereign risk, which is exactly what occurred here, and which is a qualifying risk under international law. And in this regard, we refer the tribunal to Ambiente Oficio versus Argentina, which recognized the, quote, risk of the host state's sovereign intervention made the risk at issue a qualifying one, not merely an ordinary commercial risk akin to a creditor's risk. Now, Morocco contends that I believe they appear to have abandoned to a certain extent their emphasis on there being an operational or investment risk, but that's clearly there is no such requirement. The FTA nowhere requires a qualifying investor to assume any particular kind of risk. Second, Morocco has implicitly acknowledged that the Salini itself does not even require that. Third, various tribunals have recognized other kinds of qualifying risks, such as market, financial, and political risks, as in Kiborax versus Bolivia, or unanticipated changes to market conditions. In any event, this is really not an issue here. Risk was clear, and again, there is an emphasis in Morocco's submission to it being important that each individual entity have that risk, and that's simply not the way this investment should be looked at. It is the unity of the investment is essential to recognize when considering all aspects, and the risk is clear. The risks of loss were to the entire investment structure. And it bears noting also that Morocco is incorrect that the risk is somehow supposed to be tied to contribution, that because and they also that they bore no risk in this regard. The use of the disjunctive or in the FTA makes plain that assumption of risk is a wholly separate characteristic from commitment of capital or other risk resources. But in any event, because claimants did in fact contribute funds, commodities, and deep investment management expertise to the investment, this line of argument is moot. For these reasons, even if the so-called Salini test were arguably applied to the claimant's investments satisfy it. Now let me address Morocco's second objection. And we have to return to the definition of investment in FTA Article 1027 in this regard. The second way in which Morocco distorts that definition is again the way in which it once again reads the or out of it, this time with respect to the phrase owns or controls directly or indirectly. This is the basis for part of Morocco's second objection. The phrase plainly states owns or controls, and the US has acknowledged in its submission that the phrase is disjunctive. Morocco again ignores the term or and argues that the only form of control that qualifies is one that involves some kind of a ownership interest. And that was reaffirmed in Morocco's presentation earlier today, where it insisted that somehow there has to be some kind of proprietary interest in connection with the control factor. That simply is not in the language of the FTA, and it is unsupported in any of the cases addressing the particular the issue where you have ownership or control. The control, in order for it to have any meaning whatsoever, it has to be viewed independent of any proprietary interest. And to be clear, the fact that we make this distinction in no way suggests that we do not have ownership interests. Claimants clearly have ownership interests in the investments and have demonstrated that. The U.S. onshore feeder owned 99.96% of the master fund, and the master fund in turn owned 100% of the participating shares of VMFQ1, the investment vehicle that held title to the commodities. This entitled the U.S. onshore feeder to participate in the profits and surplus assets of VMFQ1. And indeed, CCM was a key entity in this issue. Now, I will note that Morocco, in its demonstrative, showing a diagram of the corporate structure, makes this reference to VMFQ1 by putting a box next to it with a question mark for management shareholders. But again, this is another example of a misleading comment by counsel for respondent. Under the VMF Articles of Association, management shares, quote, confer no other right to participate in the profits or assets of the company. So the economic interest in Q1 is held by the master fund, which held the participating shares. And those shares are the important ones to consider, not the management shares, the participating shares. The fixation on management shares that Morocco seems to have is totally unwarranted. For 2 out of the 3 entities, it makes no sense either, because there were no such shares for 2 of them, or they belong to CCM. And for the third, Q1, claimants clearly had the economic interest through its participating shares. Now let's turn to the control issue, and returning to CCM in particular. With respect to the control that it exercised, that control is incontestable. Each investment vehicle involved in the Samir transactions, including VMFQ1, 2014-1, and 2015-1, was created by CCM and had investment management agreements with CCM that appointed CCM to be the sole entity capable of making investment decisions on their behalf. And let's look at some of the language of these investment management agreements. The investment management agreement between CCM and VMFQ1, for example, plainly states that CCM was appointed to invest and reinvest the net assets in such a manner as may determine for CCM in its sole discretion. So CCM had the sole discretion to invest and reinvest those assets. Section 1 reiterates again and again that CCM will act as the sole investment manager with sole authority and responsibility for VMFQ1's investment decisions. So again, no really issue with respect to, if you look at the language of these agreements, the total control that CCM had with respect to the vehicles. Section 2 provides that CCM is authorized on behalf of VMFQ1 and through it, Celadon, to exercise all rights, powers, privileges, and other incidents of ownership. So to the extent that proprietary matters are supposed to be important, which is our position, it is not, and the language of the FDA makes that clear. Here's an express provision that shows that CCM was authorized to exercise all incidents of ownership with respect to the investments, including by bringing applicable treating claims such as the ones brought here. Similarly, the portfolio management agreement between CCM and 2014 charged CCM with effecting the purchase or sale of commodities on behalf of 2014-1 and gave CCM full power of substitution and full authority in 2014-1's name. Now, the 2014-1 indenture also expressly charged CCM as portfolio manager to protect the investments by procuring any action, including by bringing legal proceeding, such as this one. Now, I won't go through them for the sake of brevity, but the evidence shows that the portfolio management agreement and indenture for the 2015-1 notes provides the same broad managerial authority to CCM. It is unequivocally clear that under the management agreements, CCM was specifically assigned to stand in the shoes of all of the investment vehicles to assert any action on their behalf and to protect the investments as a whole. But moving beyond these foundational agreements, this is the reality. As claimants diagram 1 from their counter memorial shows, CCM exercised control over each and every aspect of the investment and maintained control over each and every one of the investment vehicles. To put it colloquially, all roads start with and lead back to CCM. Now, Mr. Zwick has already testified in his witness statement that in his capacity as the chief operating officer of CCM, he personally signed the MCTA and CSA on behalf of the investment vehicles. You will hear Mr. Zwick testify tomorrow that CCM employees were the only points of contact with Samir on behalf of the investment vehicles. Indeed, it was CCM, including Mr. Zwick personally, who set up each investment in the first place. So this kind of all-encompassing control that CCM had over the investments is precisely what the FTA looks to and permits for standing purposes. As the United States has expressly acknowledged in this proceeding, there is no definition of control in the FTA, and certainly not one that requires an ownership interest. I believe Morocco has invoked Aguas del Tunari versus Bolivia. That case is not apposite. There, the tribunal was not interpreting the term control in the context of the phrase owns or controls, which is the FTA provision at issue, but rather in the context of the definition of a national of a contracting party, which factored in the question of whether nationals control directly or indirectly the legal person at issue. Although the Aguas del Tunari majority concluded that the word controlled is not intended as an alternative to ownership under that particular definition, under that particular treaty, such a conclusion here simply would not comport with the plain language of the FTA, which uses the disjunctive. So there is no basis really to depart from this clear framework and to instead defer to conceptualizations of control under US accounting principles, which Morocco has done and which was again referenced in Mr. Harris's presentation earlier today. As claimant's expert, Mr. Walk has testified, accounting rules like IFRS and US GAAP are intended to enable financial statement users to reach informed conclusions about accounting data, not to evaluate standing under an FDA. Even the very accounting documents that Mr. Taylor cites, relies on, acknowledge that accounting classifications are not legal classifications. Even putting aside their lack of legal implications, while US accounting principles may be helpful in assessing whether claimants controlled vehicles in certain respects, they're of no help whatsoever in answering the questions posed in this hearing, and that is whether claimants controlled the investments. That is a question of international investment law. Now, control can and should be determined by looking at the operative facts. Here, those facts point to the conclusion that CCM controlled the investments. Contrary to Morocco's arguments, claimants, they continue to believe their analysis with respect to de facto control in Thunderbird versus Mexico and BMEX, and believe that those can be adapted to the case here. But Morocco wrongly focuses on the points that in Thunderbird Gaming, the critical ones, that claim that they held a minority interest in the entity at issue, which they focus on, and BMEX, the tribunal also contemplated some level of share ownership. But again, as explained in claimants' papers, these cases are not relevant. They were brought under Article 1117 of NAFTA, and those cases involved in the tribunal's analysis is whether the claimant controlled a locally incorporated entity, and they're not exact fits for this analysis, where we're dealing with claimants controlling the investments themselves. The most salient point of those two decisions, however, which claimants have encouraged this tribunal to consider, is the idea of de facto control with no regard to the size of any ownership interest. And that is what should be the focus here. An important principle here is that CCM, although it had exercised de facto control. And contrary to Morocco's assertion, CCM here can be likened to SD Myers Inc. in SD Myers, Canada. In that case, SDMI was a US corporation owned by members of the Myers family. Seeking to expand its waste disposal operations in Canada, SDMI established a Canadian affiliate, SD Myers Inc., to do so. SDMI did not own any shares in Myers Canada, but the two companies were owned and managed by the same individuals in the Myers family. But importantly, the tribunal upheld SDMI's standing as an investor on the basis of SDMI's control of Myers, given that the individual that facilitated such control, Mr. Dana Myers, quote, controlled every decision, every investment, every move by Myers Canada. Here too, CCM controlled every decision, every investment, every move by the investment vehicles that it had created, which means that CCM also controlled the investment themselves. Now, Morocco has argued that the situation is different for claimants because Mr. Myers was able to exercise such control through his ownership interest in Myers Canada. But that was not the point of SD Myers versus Canada. That was not the point of that case. The tribunal focused on the fact of SDMI's control, not the source of that control, because SDMI was the claimant, and the SDMI, the claimant entity, had no ownership interest at all in that case. Now, the fact that the source of CSCM's authority over the relevant investment decisions is contractual rather than ownership-based does not put in any different position the situation than SDI if there is sufficient evidence, and there is, that CCM controlled the investments. Just as much as the investment at SD Myers was all in the Myers family, so too here the investments were all in the Carlyle family. Indeed, every one of the claimants, as well as the investment in vehicles, are indisputably related to Carlyle. Now, I do want to spend a few minutes on the sleeve transactions, which counsel for Morocco spent some time on. The sleeve transactions, again, are much ado about nothing. Morocco made it a central point of its reply on jurisdiction. But this is, again, nothing more than a distraction. To avoid any doubt on this point, claimants have submitted the VM MCTA, which govern the sleeve transactions, and fully supports Mr. Zuick's testimony that the purpose of the transactions was simply to transfer title to the commodities. It had the right to do so. It had the control over those entities that enabled it to do so. And why does that matter for jurisdictional purposes? It's not clear. It's not really clear. Where title lay among the various vehicles at a specific point in time is not determinative of anything. To sum up, the claimant's investments are indeed covered investments as defined in Article 1027 of the FTA. They are assets owned and or controlled directly or indirectly by claimants, and we'll get to that particular issue in the next segment of the presentation, and that have the characteristics of a typical investment, such as the obvious undisputed expectation of gain or profit, the clear commitment of capital and other resources, such as the commodities themselves and the investment management expertise, and qualifying risk, even though, and though not required, they also satisfy the duration requirement. Therefore, Morocco's first and second objections are meritless and should be rejected. Let us then go to the second and fourth objections, or elements of the second and fourth. And here I turn to the next FTA provision at issue, Article 1027, definition of investor of a party. Article 1027 of the FTA defines investor of a party as including, quote, an enterprise of a party that concretely attempts to make, is making, or has made an investment in the territory of the other party. As part of its second objection, Morocco contends that claimants do not satisfy this definition because the investments were allegedly not in the territory of Morocco. And for its fourth objection, Morocco suggested claimants were not active investors that made an investment. Morocco's arguments, however, are once again unfounded in the text of the FTA, which is an applicable case law and fact. Again, not much attention was paid in the response in Morocco's presentation earlier, but I will at least deal with this issue, the issue of being in the territory. Morocco has already conceded that the commodities were in the territory of Morocco, and rightly so, since they were physically stored in Samir's tanks in Mohammedia, Morocco. Morocco has also conceded that the CSA is governed by Moroccan law. Despite these notable concessions, Morocco points out that the MCTA and the other investment agreements are governed by New York law, but this is a meritless argument that finds no support either under the FTA language or in international case law. Contractual rights by their nature have no physical presence, nor can claimants' contractual rights be examined as a discrete part that must have its own presence in the territory of Morocco, separate from the commodities. As a matter of logic, given that the commodities were located in the territory of Morocco, the contractual rights tied to those commodities were located, if anywhere, in Morocco. And this is yet another example of Morocco derogating the principle of the unity of investment. Claimants' contractual rights cannot be disaggregated or divorced from the commodities themselves. Indeed, investment tribunals evaluating intangible instruments, such as financial instruments, have long held that the location of such intangible assets is based on where and or for the benefit of whom the funds are ultimately used. Here, the investment agreements with Samir had clear ties to and effects on Morocco because they facilitated the transactions that served the Moroccan economy with a reliable supply of fuel and crude oil that was critical for the operation of Morocco's oil refinery, which in turn also provided jobs. The benefit to Morocco was clear. The tribunal in Deutsche Bank versus Sri Lanka rejected the very argument that Morocco is advancing on this issue, that the governing law of an agreement determines the territoriality of the contract rights, and held that the law governing the hedging agreement at issue, which was English law, did not undermine the nexus with the territory of the host state because, quote, it was undisputed that the funds paid by Deutsche Bank in execution of the hedging agreement were linked to an activity taking place in Sri Lanka, the country at issue, and served to finance its economy, which is oil dependent. And the choice of English law was nothing more than a reflection of the reality of modern banking, that London is the world's first financial place. Again, the contractual rights at issue here were plainly linked to activities taking place in Morocco and which were intended to benefit the Moroccan economy. In sum, claimants' investments were unquestionably in the territory of Morocco. Turning back to the definition of investor of a party, Morocco's next argues in its fourth objection that the phrase concretely attempts to make, is making, or has made an investment signals an active investor requirement. And on the basis of that suggests that none of the claimants have standing. This attempt to read an active investor requirement into the FTA is very misguided, for neither the term concretely nor the term make or made implies such a requirement. As to concretely, as explained in our papers and as Professor Schroyer has explained, the better reading of the entire phrase under international investment law principles is that the term applies only to attempts to make, which would address questions concerning pre-investment activities. applying concretely not only to attempts to make, but also to made, which suggests that a qualifying investor has to make the investment. But there are numerous cases recognizing an investment that is acquired by the claimant after it's already been made, and adopting Morocco's reading would render such case law meaningless. As for make or made, interpreting the term as requiring a certain level of activity would in fact negate language in the definition of investment, which expressly allows for, among other things, indirect investment, indirect ownership of the investment. And again, this is an issue we will come back to. In addition, as explained by Professor Schroyer, there is no such thing as an active investor requirement under international law generally, and that should dispose of the matter. On the contrary, investment tribunals have frequently upheld standing where the claimant has demonstrated either ownership or control of the investment at issue, no more and no less. Because claimants owned and or controlled the investments here, they indeed made an investment for purposes of fulfilling the definition of investor of a party. Now, Morocco has relied on and continues to rely on the Standard Chartered Bank versus Tanzania case, but as claimants have pointed out, that case really is not applicable because the tribunal was interpreting different language in that case. The phrase investment of in the UK Tanzania bit. The bit covered any legal dispute arising between a contracting party and a national or company of the other contracting party concerning an investment of the latter in the territory of the former. In other words, it was very specific with respect to the language that related to the territory of. So the term investment was defined in the treaty as every kind of asset admitted in accordance with the legislation and regulations in force in the territory of the contracting party in which the investment is made. Totally different circumstance from the circumstance here. Because this definition used the term made rather than own or hold, the tribunal concluded that an investment of an investor had to be made by that investor in some active way rather than simple passive ownership. Nowhere in the UK Tanzania bit did it use the terms own or hold, whereas here the FDA does use the phrase owns or controls in the definition of investment. The tribunal's determination was primarily driven by the unique facts of that case, which is also significant and which, contrary to Morocco's assertion, are not analogous here. Claimant was a UK entity in that case which sought the benefits of Tanzanian loans held by its Hong Kong subsidiary. The Hong Kong subsidiary had acquired these loans from a Malaysian bank, and the UK claimant made no contribution to the relevant notes, nor did it exercise any control over any credit to the Tanzanian debtor or provide any direction to the Hong Kong subsidiary related to making the loans. Morocco has argued that the facts in this case and the facts in that case are analogous to all of the claimants, but that is patently false. As discussed earlier, the US onshore feeder unquestionably contributed funds to the investments through VMFQ1, and CCM unquestionably controlled every aspect of the investment. Now let me turn to the response. So to sum up, when properly viewed as a whole, claimants' investments, including both the commodities themselves and the related contractual rights, were plainly in the territory of Morocco, and claimants made those investments as evidenced by their ownership and or control over the investments as a whole. As a result, Morocco's second and fourth objections should be rejected. And by the way, I have to note that Morocco cannot be correct, both that claimants must have some kind of ownership interest in the investments, which is a passive posture, according to Morocco, and the claimants must have actively made the investments. If so, the FDA would be limited to protecting only investments that claimants directly created or obtained, reading out the express language or control and or indirectly from the treaty. That just cannot be the case. So those objections should be rejected. Let's turn to the third objection, though, which is based on Morocco's view of Article 1015.1a, which is which provides that a claimant on its own behalf may submit to arbitration under this section a claim that the respondent has breached an obligation under Section A and that the claimant has incurred loss or damage by reason of or arising out of that breach. Claimants meet this language because they have brought their claim on their own behalf. Respondent seems to seek to portray it as if these claims are not being brought by the claimants on their own behalf. They are. They are not being brought on behalf of a locally incorporated entity. And they have alleged that they suffered losses due to Morocco's breach of the FTA. And that should be sufficient for purposes of an Article 1015A1 claim. Morocco and the United States have argued that, that this provision prohibits a qualifying investor from bringing a claim under this provision, except where it has incurred direct losses. And this is a key point that respondent seeks to bang home. In essence, they contend that evidence of direct material evidence that damage is a requirement for standing. But there is simply nothing in the text of Article 1015.1a that supports that position. Instead, the only limitation on the type of loss or damage claimed, and by the way, not proven, because this is not a merits hearing, it's a jurisdictional hearing, is that it must be one by reason of or arising out of respondent's breach. Morocco has argued that CCM, for example, has no standing because any potential harm to CCM was allegedly limited to the loss of its management fees. And they also assert that such a loss is merely a byproduct of the loss of the commodities at issue, not necessarily by reason of Morocco's action. But the case law is clear that neither claimants as a whole nor each claimant individually needs to prove damage or quantify their damages at the jurisdictional stage, which seems to be what respondent is asking that claimants do. The damages issue is for the merit stage. And this is extremely important. And for example, in Mikula, Romania argued that in the absence of quantifiable damage, the claimants lack standing. But the Mikula Tribunal rejected that argument and held that the extent or existence of actual harm suffered by one or more of the claimants, if respondent is held liable, need not be addressed at this jurisdictional stage. Similarly, in Total versus Argentina argued that there was no justiciable dispute between the claimant Total had suffered no damage because the claimant had suffered no damage. The tribunal, however, disagreed, finding that the evidence submitted by Total appeared sufficient to conclude prima facie that Total may have suffered economic prejudice from Argentina's actions. The tribunal further held that, quote, the possible uncertainty as to the final amount of the damages does not represent a bar to jurisdiction, but rather an issue to be decided in the merits. And this is extremely important because essentially a sovereign must be held accountable for its actions, although regardless of damage, and though claimants clearly sustain damage, and we will further demonstrate that as we have in our papers, they should not be forced to prove all of their damages at this jurisdictional stage. Indeed, tribunals such as Bywater Gulf versus Tanzania have found that proof of economic loss is simply not a prerequisite for establishing a breach of the treaty. In the arbitral tribunal's view, the absence of economic loss or damages is primarily a matter of causation and quantum, rather than a necessary ingredient in the cause of action of expropriation itself. The better way to understand FTA Article 1015.1a is that claimants only need to demonstrate at this stage that they possess a prima facie claim on their own behalf based on Morocco's breaches of the FTA for losses that claimants have incurred. As stated by the Mikula Tribunal, jurisdiction is proper so long as respondent does not assert that it was unable to understand what claimants are claiming, and out of which alleged specific breaches of the BIT their damages allegedly arise. Morocco does not make that claim here, nor could it, since there's no question that the losses at issue, the loss of the commodities, the loss of contract rights, and the loss of the value thereof are ones that claimants have claimed are by reason of or arising out of Morocco's proper actions. By contrast, the alternative reading endorsed by Morocco and the United States that claimants must prove direct damages fails under the rules of treaty interpretation in Article 31 of the Vienna Convention, international investment law, and the history of the United States' investment treaty. Again, repeating Article 31 of the Vienna Convention, it states that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. This mandates the primacy of the FTA's text in treaty interpretation. And now nothing in the terms nor the ordinary meaning of Article 1015(1)(a) prohibits a claim from seeking to recover for losses suffered directly by an entity incorporated in a third state. There is no qualifier of direct anywhere in the text. That article is silent as to this possibility. The fact that it's silent doesn't mean that it is barred. To the contrary, the right to proceed under Article 1015(1)(a) covers any investment, and here it's critical, direct or indirect, and the only exception is the situation covered by Article 1015(1)(b), which again is not applicable here because we are claiming on the behalf, the claimants are claiming on their own behalf under Article 1015(1)(a). And looking further at the context of 1015(1)(a), and in light of the objects and purpose as explained in claimants' papers, it is further confirmed that Morocco and the United States expressly consented to arbitrate all claims of alleged violations of Chapter 10, Section A of the FTA that related to any covered investment. Specifically, the FTA permits a claimant to file claims arising from investment disputes, which, although undefined in the FTA, previously has been defined in the 1994 U.S. model bid as a dispute relating to an alleged breach of any right conferred, created, or recognized by the treaty with respect to a covered investment. And as noted, the definition of investment under the FTA is very broad. Every asset that investor owns or controls, and I repeat, directly or indirectly, that has the characteristics of an investment, as in the territory of the other party. To omit the directly or indirectly language from the definition really is not right, it's not correct, and it's not consistent with Article 31 of the Vienna Convention. It makes it clear that the express terms of the FTA are what take precedence in treaty interpretation. Whatever discussions of the parties' intent may exist outside of the FTA's text, both the ILC, the International Law Commission, and investment tribunals have stated that the only thing that matters is the parties' objective intent, as evidenced by the treaty's final language. For example, in Wintershall versus Argentina, the tribunal explained the carefully worded formulation in Article 31 is based on the view that the text must be presumed to be the authentic expression of the intention of the parties. The starting point of all treaty interpretation is the elucidation of the meaning of the text, not an independent investigation into the intention of the parties from other sources.
Mr. Ordway, you have to give a little bit of time to the court reporter. You are going very, very fast now.
Thank you.
So let's wait for 1 minute so that the court reporter, you don't have to write this now, just gets her breath again, and then you continue. You were going very, very quickly.
Thank you, Mr. President. I will
Fine,
resume.
Mr. President.
Now, in Morocco's opening presentation, counsel for Morocco argued at length that the position that respondent has taken in objection 3 and the non-party submission made by the United States amounts to a subsequent agreement or subsequent practice to Article 31.3 of the Vienna Convention. And that their purportedly shared interpretation of Article 1015(1)(a) should control the tribunal's interpretation thereof. Claimants strongly disagree. First, there is no subsequent agreement. To the extent Morocco and the US are of one mind, and it's not entirely clear that they are, I would say that the United States has made it very clear that they're not opining on the particular facts at issue in a case. But anyway, regardless, what they're trying to do is amend the FTA and force a new binding interpretation without abiding by the agreed upon specific mechanisms for doing so. There is a specific mechanism in the FTA for reaching the kind of agreement that Morocco is saying they already have. Article 22.2 is plainly a provision concerning amendments, and this is what we would say is what Morocco is doing, actually amending an agreement, because the language that they purport to say is there is simply not there. But the 22.2 of the FTA, which concerns amendment, states that the FTA parties may, quote, agree in writing to amend, unquote, the treaty, but that such amendment will only enter into force after the parties complete any necessary approval procedures. Neither Morocco nor the US has represented that any such amendment procedures have taken place. The fact is they haven't. Article 1021.3 of the FTA is a provision concerning joint issuance of an interpretation of the FTA. And it provides that a decision of the Joint Committee declaring its interpretation of a provision of the FTA shall be binding on a tribunal. The Joint Committee is a specifically defined group described in Article 19.2 of the FTA. But again, neither Morocco nor the US has represented that any such Joint Committee decision has been issued. Now, none of the, nor is there any subsequent practice here. There's, per the definition set forth by subsequent practice, must be a concordant, common, and consistent sequence of acts or pronouncements, which is sufficient to establish a discernible pattern implying the agreement of the parties regarding its interpretation. This is the first time there's been any submission by either of the parties regarding this particular FTA, let alone the specific provision of Article 1015(1)(a). And Morocco's emphasis on the parties' submissions made in the context of NAFTA is inapposite. This is not a case brought under NAFTA, and Morocco itself is not even a party to the NAFTA. So there can be no applicable subsequent practice from any such interpretation. In light of the complete absence of a discernible pattern of consistent, concordant interpretation of this FTA, there is clearly no subsequent practice here that should be considered in interpreting Article 1015(1)(a). But even assuming, let's assume for the sake of argument that there is some sort of substantive agreement or subsequent practice here, which is not the case. There's been no agreement under the law and no practice here. It would be a flagrant violation of the good faith principle in Article 31(1) of the Vienna Convention for the tribunal to take such subsequent agreement or subsequent practice into account in this arbitration, where it is clearly arising for the first time to influence the outcome of this proceeding. Claimants clearly had an expectation when it filed its claims that the treaty would be interpreted in accordance with the plain language of the terms of that treaty. And in the absence of a subsequent agreement, which we've established did not exist, and subsequent practice, it would be completely unfair to take what Morocco is claiming as an agreement and impose that in this arbitration. If anything, what has been agreed to, if there is in fact agreement, can only be applied to a future arbitration, not to this arbitration, because it would be a violation of good faith to do that. And some of the sources that respondent has asked to be introduced into the record acknowledge that when a subsequent agreement seeks to amend, not merely interpret the treaty at issue, such agreement cannot be binding on pending proceedings. And this is with respect to Mr. Gazzini, the commentator. And the reason for that is, quote, there is a need to protect the investor and to ensure that the treaty provides a stable, legal, and predictable environment. Accordingly, it would simply not make any sense, and it would not be in accordance with Article 31 of the Vienna Convention to take into account any purported subsequent agreement or subsequent practice between Morocco and the United States, especially in this particular situation where the purported subsequent agreement or subsequent practice is being raised for the very first time with respect to this specific FTA. Let me say a few things about the Barcelona Traction Rule. In support of the third objection, Morocco relies on Barcelona Traction, a decision from the International Court of Justice, as its basis for arguing that only direct loss or damage gives rise to a cognizable claim under the FTA. This tribunal should be well aware, however, that as Professor Schroer has noted, the International Court of Justice has acknowledged that its decisions, given in the context of diplomatic protection on the basis of customary international law, do not apply in the framework of contemporary international investment law, which is dominated by treaties. So again, the tribunal must focus on the plain language and ordinary meaning of the FTA itself. With these interpretive principles in mind, I return to the definition of investment in Article 1027 of the FTA that we discussed earlier. The language is clear. Covered investments include every asset that a covered investor owns or controls directly or indirectly. Since the FTA thus includes indirect investments, it stands to reason that it also covers loss or damage to such indirect investments. Otherwise stated, there is no logical difference between indirect damage to an investor and damage to an investor's indirect investment. It just does not make any sense. And in Waste Management versus Mexico, the tribunal held that where a treaty spells out in detail and with precision the requirements for maintaining a claim, there is no room for implying into the treaty additional requirements, whether based on alleged requirements of general international law in the field of diplomatic protection or otherwise. And that's what we believe is Morocco is seeking to do here, to read something into the treaty that is simply not there. Waste Management overall provides a helpful parallel. There, the investment was a concession agreement between the city of Acapulco and Acaverde, a Mexican company, and the arbitration arose from Mexico's alleged breach of that agreement. Acaverde was a wholly owned subsidiary of the US claimant by way of a Cayman Islands holding company. Mexico argued that the U.S. claimant did not have standing because the direct shareholder of Aca Verde was in fact a Cayman entity. While an issue before the tribunal was whether the claimant was bringing its claim under NAFTA Article 1116 or Article 1117, the tribunal ultimately saw no issue either way with an investment being made through a third non-NAFTA state, so long as the beneficial ownership at relevant times was with a NAFTA investment. The tribunal also did not see Article 1117 as foreclosing claims based on an investment made through an intermediary located in the third state. And the tribunal in GAMI versus Mexico also expressly rejected the United States argument that Barcelona traction was applicable in the NAFTA Article 1116 context, and it relied on the Elsie case, in which the ICJ itself accepted the US shareholder of an Italian company could bring a treaty claim against Italy for major measures imposed on that company. So consistent with shareholding being the classical form of an indirect investment, there is also a long-standing case law protecting shareholders in investment treaty operation, which holds that indirect investors are protected not only with respect to shareholding interests, but also with respect to the assets of the company that they own or control indirectly. And that is critical here because we have demonstrated that it's the assets that were lost here. And for example, with respect to CCM, CCM had control of those assets, and there should be no doubt with respect to that. And their loss was the loss of those assets. We would argue it was a direct loss since they had direct control over those assets. And their losses were the commodities themselves. And the result of that was, as has been demonstrated, that CCM went completely out of business. And again, to return to the notion that the assets are what of the company are what matters here. In Mera versus Serbia, Serbia argued that the assets of the claimant's investment vehicle were not assets by a protected investor. The tribunal rejected Serbia's argument, holding that the BIT at issue did not exclude indirect investments from protection, and noting that in situations where a shareholder controls legally or factually the company that owns the assets at issue, tribunals may consider those underlying assets to be the investment of the shareholder, because the claimant before it invested both in its investment vehicle and through the control of such vehicle. The tribunal held that claimant was entitled to bring claims not only for the impairment of the value of its shares, but also for the impairment of its subsidiaries' assets. Now, just very briefly, Morocco's so-called leading authority for its opposition position is Postova Bank, the facts of which Morocco alleges are analogous to this case. Morocco, however, is wrong on this for two reasons. First, again, there is no limitation in the FTA that requires only the ultimate owner or beneficiary of the assets at issue to submit claims to arbitration. And claimants have articulated the basis for their standing under the FTA. As Morocco noted, that the second of the two Postova Bank claimants, Istro Capital, did not make reference to its shareholding in Postova Bank or otherwise explain which provision of the Cyprus-Greece bit enabled it to submit claims regarding their assets. Here, claimants have clearly laid out that the FTA allows any investor that owns or controls directly or indirectly the asset at issue, not just the ultimate owner or beneficiary, to bring a claim. Claimants have demonstrated that they do in fact have clear ownership interest through the US onshore feeders participating shares in the master fund, which gave them all the necessary economic interest, and the master fund's participating shares in VMFQ1, which also gave it all the economic interest, as well as clear control over the investments, particularly through CCM. Second, with respect to Postova, the investments in Postova were not even qualifying investments in that case. The tribunal ultimately held that Postova Bank, not just Istro Capital, did not have standing because the Greek government bonds at issue were not qualifying investments under the applicable BITs. In other words, the Postova claimants overall were doomed from the start because theirs was not a qualifying investment, putting aside the question of whether they were qualifying investors. So here, for all reasons stated earlier, claimants' investments are, in fact, qualifying investments under the FTA. Moreover, Postova Bank and the other decisions cited by Morocco articulated a purported principle of separate legal personality, which is no longer an absolute rule. And this has been clear from the case that we recently added to the record, Cube Infrastructure versus Spain, which states the principle of legal personality can be altered by treaty, and investment treaties almost always do so. In that case, the tribunal noted that Spain, in taking a position similar to Morocco's, failed to contend with the ECT's broad conceptualization of investment, given the express reference to the proposition that ownership or control of any asset can be indirect. Here too, Morocco has ignored the broad definition of investment in Article 1027 of the FTA and blindly relied upon Postova and its progeny. That is not the correct approach. Claimants reiterate that the commodities and the contractual rights are assets owned and or controlled directly or indirectly by claimants, and that is sufficient under the FTA for claimants to claim losses pertaining to those assets. Finally, I'd like to briefly note that the positions of Morocco and the United States conflict with the United States' historical interpretation of NAFTA Article 1116, the parallel predecessor of the FTA Article 1015(1)(a). For example, in S.D. Myers and Pope and Talbot, the United States argued that where the qualifying investment is not a separate company, quote, any damage to the investment will be a direct loss to the investor, and the investor will have standing to bring a claim under 1116. Applying the same interpretation to the identically worded FTA and claimants' investments, which are not companies, they're the assets, claimants clearly have standing to bring a claim under Article 1015(1)(a). And by the way, I would say that to the extent the United States has raised this issue, the issue that they have raised in this case, they have made submissions on this issue in 6 different matters, and in only one of those 6 matters that the tribunal ruled in its favor. In addition, the policy arguments...
Sorry, can I just raise a point, Mr. President? I don't want to be difficult, but I'd appreciate a time check. Mr. Ordway said he wanted an hour and a half originally. I was cut back from 2.5 hours and I wanted to 2 hours, and I stuck to it. I don't mind a couple of minutes over, but it seems that we're a bit over now.
I take Mr. Harris's point. I'm within 5 minutes of finishing.
Thank you, Mr. Ordway.
No problem.
That's fine.
I just want to add that the policy arguments that the United States has previously put forth in support of Barcelona attraction do not apply here. There's no risk of double recovery at all. And even accepting arguendo Morocco's and the United States direct damage requirement, which we both do not accept that as a requirement. Moreover, we say that to the extent that it is the tribunal views it as a requirement, we have complied with that requirement also. Claimants did suffer direct losses ranging from the U.S. onshore feeders' loss of over $130 million to CCM being driven to fully unwind its commodities business in the wake of Morocco's actions. And by the way, Mr. Zwick will testify to that very clearly tomorrow. For these reasons, all of these reasons, Morocco's third objection should be rejected. To summarize, the commodities and contractual rights at issue are covered investments under FTA Article 1027 because they are assets bearing the characteristics of covered investments, and they were owned and or controlled directly or indirectly by claimants. Therefore, Morocco's objections number 1 and 2 should be rejected. Claimants are also covered investors under FTA Article 1027 because they made the investments in the territory of Morocco. Therefore, Morocco's objection number 2 and 4 should be rejected. And claimants are properly brought under FTA Article 1015(1)(a) on claimants' behalf in connection with Morocco's breach of the FTA. And claimants' losses by reason of or arising of out of a breach by Morocco. Therefore, Morocco's objection number 3 should be rejected. In closing, I'd like to come back to a few observations I made to start. Morocco has presented any number of positions that may sound superficially persuasive at first, but they all fall apart or have nothing to do with the jurisdictional issues that matter for this hearing. The unity of the investment principle in particular undercuts many of Morocco's arguments, and the burden of proof on jurisdictional objections lies with the objector. We have demonstrated that there has been damage, and that damage is clear. And on that basis, and on the basis of all of the other points that we have made here, we believe Morocco has failed to demonstrate that any of its objections are well-founded. We also respectfully ask that the tribunal keep in mind that if Morocco has its way, no one will ever be able to hold Morocco to account for its actions, and that is critical. Thank you very much, Mr. President, co-arbitrator.
Thank you. Thank you very much, Mr. Ordway. Just let us get a time check from the secretary.
2 hours, 5 minutes, and 5 seconds.
So you were absolutely also perfect in your timing, Mr. Ordway. Very good. So we had in our schedule, we had some time now for tribunal questions. And so I will give now the floor first either to Professor Guijera Naón or to Mr. Wordsworth, whoever wants to take the floor first.
Excuse me, Mr. President.
Yes.
If I could, would it be possible for me just to get a glass of water? It will take.
Of course. It's a very good idea. Thank you, Mr. Ordway. We have been long. Let's make a 5-minute pause, and it's now 1936. So we come back in 1945. 1945 Spanish time, whatever it is in the rest of the world.
Thank you, Mr. President.
So we are now back in our hearing. I see Mr. Wordsworth, Professor Guijera Naón, and Mr. Harris, Mr. Ordway. I also see Diana Burden, which is always nice, and to actually see our court reporter. And I think we can start. Very good. So we resume the hearing, and I will now give the floor to my colleague, Sam Wordsworth, who has a couple of questions for the parties.
Thanks very much, Mr. Chairman. The first question concerns what Mr. Harris was saying about authentic interpretation and his reliance on Article 31(3). And what I'd be grateful to hear further from at any stage, doesn't have to be now at all, and is leaving to one side the claimant's point that this is not really a matter of interpretation, but one of amendment. Still, does it make any difference that this interpretation, subsequent agreement, subsequent practice, is coming within the context of litigation, bearing in mind also the point that the claimant is making, that the United States has made inconsistent statements in other cases. So what weight or what degree do we take into account that this subsequent practice or subsequent agreement comes in litigation? And in this respect, although you did refer us to Judge Crawford, as I read that excerpt, it appeared to me to be referring to specifically to the FTC interpretation. That is a specific mechanism for an interpretation in the NAFTA, as opposed to an agreement or practice within the litigation outside the existence of that FTC interpretation. And I should say this, like all the questions, 2-3 questions I have, is as much for the claimant to come back on as for the respondent.
Without wishing to interrupt you, may I add an additional footnote to what you said? Irrespective of the context, if there is an interpretation of a treaty by the state parties, can it have retroactive impact, or should it be only for the future?
And let me say the following. These are very deep questions of international law. And instead, I would propose that instead of having now some improvised answer, why don't you make a note of them and you come back to us on Friday, when we have a whole day to go, and we will be all fresher to get into these questions. And I would propose that we reserve that you take this time till Friday to really think through it and research to the extent you can, and that you come back to us on this question of authentic interpretation, which is, of course, one of the basic issues in this case on Friday. It is a point of high interest to the tribunal. Sam, would that be appropriate in your opinion, that we come back on Friday?
Absolutely appropriate, and all the more so in relation to my next question, which is about the Standard Chartered Bank Tanzania case, which both parties have referred us to today. And I think it would be useful, for me at least, to have a further look at how Standard Chartered has been picked up in subsequent cases, ideally in terms of cases with analogous wording, but of course it has been picked up in cases which do not have wording that's analogous either to the wording in the Standard Chartered Bank and Tanzania BIT or our current treaty. But it would be useful to hear from the parties a little bit further on how Standard Chartered Bank is being regarded as persuasive or not. This is more a question for Mr. Ordway, which I think is just a question of clarification, which I didn't absolutely follow, although I see he is relying on a principle concerning the unity of investment. I saw how that fed into his case on the existence of an investment. What I wasn't absolutely sure is whether that was also feeding into his case on Article 1015. When he first introduced the principle, I thought maybe it was, but later it was talked about more in the context of investment alone. So the question, that's a clarificatory question, and if it is a question, if it does feature in your 1015 analysis, then obviously there would be a question as to how that principle in the context of what is an investment would apply specifically with respect to a provision that deals with the submission of a claim to our arbitration. And my final question is also to Mr. Ordway, which was simply to understand further the claimant's case on the interplay between 1015(1)(a) and (b), and how on the claimant's interpretation effective is given to 1015(1)(b).
Thank you. Thank you. I mean, 1015 A and B and the interpretation is also one of the key issues in this arbitration. And in that context, there is a very recent case, which is a case against Guatemala, and our secretary will give you now the precise reference, in which this very issue came up in an FTA with the United States, and the tribunal went one way, and there was a separate opinion of Professor Douglas, exactly on this question, and I think it would be, if both parties agree, I think it would be important that we incorporate that case into the record. And I have now to ask Ms. Rosenberg to give us the precise name. It's a case against Guatemala.
It's ICSID case number ARB 1843. It's Daniel W. Capps and Capps Cassidy and Associates claimants versus the Republic of Guatemala. The decision on the respondents' preliminary objections, as well as the partial dissenting opinion of Professor Douglas. The decision is publicly available on the ICSID website.
And it's very, very recent.
Yes, I believe the date is March 13th. Let me just check that.
Would you say the parties again, please? Cassius?
Yeah, it's Daniel. Sorry. I just want to make sure I'm not on mute. Yes. Daniel W. Capps. I might be mispronouncing it, but it's spelled Kappes, and Capps, Kappes, comma, Cassidy, Cassiday, and Associates versus the Republic of Guatemala.
And the reference is arbitration 14.
1843. I just sent it to you, Professor Noun. You should have it.
I'm sorry.
It's okay.
Thank you.
Now, let me ask you, Mr. Ordway, do you have any? This is very recent, and I stumbled on it researching our case. And since it's very recent, and it's very much to exactly, it says an FTA with Guatemala, which has the same language or similar language, and the question which arose is analogous to the one we are, or similar to the one we are discussing here, and there are the two opinions there. And Mr. Harris, the question is, do you have any objection that we incorporate that into the record, and that of course you, in the course of, or either on Friday or in a specific submission thereafter, you make whatever comments you think are appropriate? Mr. Ordway?
We have no objection, Mr. President.
And Mr. Harris, do you have any objection?
No, sir. No objection.
Very good. So we'll incorporate that as H3 presumably, and go from there. Very good. So these were the questions from Mr. Wordsworth, and now for Professor Grijera Naon. Do you have any questions for today?
No, just the footnote that I added to Mr. Wordsworth's question, but for the time being, nothing more on my side. Thank you, Mr.
Very good. So we are almost at the end. I just would like to do two things. There's one is a question, two or three, it's very factual questions, and they go, I think, basically to Mr. Ordway. I like to do the following, and that is to summarize those things which to me were obscure, and to see if I will just ask you that you confirm that I have understood the facts correctly. But before we do that, I have a question, a very specific question, but it drew my attention. And this goes to page 60 of your counter memorial on jurisdiction. I don't know if you have that. If you can have a look at it. Page 60 of your counter memorial.
Yes.
And there you have a summary, a very useful summary of all the documents which you have presented, which I found very helpful. Are you with me? Do you have that page?
I do have it in front of me.
Very good. And there I have just one point which drew my attention. You see at the bottom, you see Q1. We have Q1 is the last line of this chart.
Yes.
And Q1, we have been told, and I would kindly ask you to confirm, has legal personality.
Well,
we can barely hear Mr. Ordway. Maybe he could speak more loudly.
yes, I'm sorry. That's an interesting question. It is an entity that had no employees, had no basically no offices.
No, but legal personality. I mean, we are lawyers.
I understand. It's a separate legal entity. I think that's correct.
And if it is, I think it was Mr. Harris who said that it had legal personality, but I see that it has no audited financial statements and you put not applicable.
Correct.
And that somehow strikes me, because if it doesn't have, all companies have audited or non-audited financial statements, and if it doesn't, I don't understand how its parent, Celadon Commodities Ltd, can have audited financial statements, because they must, by definition, incorporate the subsidiary. So if the subsidiary does not have financial statements, I was just a little bit puzzled.
Well, if I may, Mr. President, again, these are accurate statements of what our understanding was. But if I would have the opportunity to confirm that on Friday, I'd be glad to do that.
Very good. And then
I will provide an explanation in any event with regard to the questions that you have posed.
If I may add, the description, as I understand it, is BMF SPC, parenthetical, Cayman Segregated Portfolio Company, Cayman, close parenthetical. And apparently, the way I understood is that company is holding the fund. But maybe I misunderstood, and maybe we have to clarify that.
No, I think that is correct. That is correct. But we will clarify.
Very good. And since we are in these annexes, these very useful annexes to your counter memorial, can I take you, and I will now try, Mr. Ordway, I will now try to summarize how I see the overall picture of the investment. And you correct me if I have understood you well, or if I am making a mistake. Because I understand that the investment are the MCTA, the CSA, the commitment letters, the terms and conditions, and these 13 confirmations, which are in page 55 of the same document. I'm page 55 of your counter memorial, Mr. Ordway.
Yes, I have it. I have it. But let me just make sure I understand your question, because
no, there are furthermore. Let me. You correct me if I will tell you, and then you correct me.
Well, no.
Furthermore, there are 3 swaps.
No, before we get to that, I mean, I think I heard you say that the investments were the MCTA, CSA, commitment letter, and confirmations. But some of those are agreements. They're not investments.
Okay. The investments are formalized.
Yes. Okay. Very
okay.
Good.
Sorry. It was my mistake.
No. That's quite all right.
I meant formalized.
Yes.
And furthermore, there are 3 swaps.
Yes.
And the swaps, I understand, were written after the forbearance agreement, and they implied that certain amounts of certain commodities were swapped for other amounts of other commodities. So that in fact, there was no new commitment of capital.
No, let me answer that. The swaps were before. The swaps were before, Professor, not after the forbearance agreement. Right. Swaps were before in the summer.
All of the Mr. President, all of the transactions at issue here preceded the date of the breach. All of them.
Okay.
Okay.
But the swaps, so let's forget about the forbearance agreement. The swaps implied that Q1 exchanged a certain commodity against another commodity with Samir, so that there was no additional contribution of funds. There was no funding requirement.
That's right.
That's correct. Again, but there were commodities contributed themselves.
Yeah, of course.
Yes.
And your point is that these commodities which were contributed as a consequence of the swap were then taken improperly by the Kingdom of Morocco.
That is correct.
Very good. So now we will focus on these 13 confirmations, which we have in page 55.
Yes.
So these 15 confirmations, some were funded by Q1, 4, and some were funded by 2014-1, as this chart shows.
Yes.
Correct?
Yes, that's correct.
And the total funded by Q1 is $70 million US dollars, roughly $69 million. Right?
Yes.
And by 2014, $235 million, and by 2015, $38 million. That's the figures which appear here.
Yes.
You told us, Mr. Ordway, you remember that chart which showed the onshore feeder, the master fund, and Q1, and you showed us 184, 157, and 136 million US dollars.
That's correct.
Would someone in your team be kind enough to put that scheme on the screen? Would that be possible?
Yes. Kim, could you do that, please? I can tell you which one it is.
It was one slide you had. I don't remember the number.
No,
but
that's what I'm trying to find the slide itself so I can give you the number.
Because it's important that we have the numbers in front of us, because I have a problem with the numbers, not with the and you will see it immediately. Because the numbers I have is 184 from There it is. Excellent. Thank you very much to whoever is handling this. Well done. Very good. Thank you very much. So you see that under this scheme you put here, the US onshore feeder, who is a claimant, puts 184 million into the master fund, who puts then 157 million in Q1, who then uses 136 million to fund the investments.
Yes.
But if I go to your chart in page 55 of your counter memorial on jurisdiction, the number is 69 million.
Yeah, the reason is, Professor, because the swaps are not listed on page 55.
Right. Yeah.
The value of the swaps are not listed. They purchased, Q1 purchased those, but the swaps are distillates and the other transactions which are not listed on page 55. You have to account for the swaps, which are the remaining value.
Because the swap.
So Q1 originally purchased the material and then crude oil, and then that was swapped.
Okay, because they did not have, because Q1 did not have the commodity which it had to deliver.
Yeah.
So there was a funding need when they made the swaps.
Yes, that's right.
It was before they purchased it before in the 103 and 106 transactions, and then swapped that for the distillate transactions. The funds came from Q1 initially, and then were swapped for the refined materials.
Very good.
Right, and I think if you add the value of the swatch, which is approximately 76.9 million, to the amount that you see on page 55, it will total the 136 million that we represented to you was the amount contributed.
And then 235 million plus 37 million, so that's 280 million roughly, were funded by 2014-1 and 2014-1 and 2015-1. They issued bonds, and the offering memorandums are there. They issued these bonds, and these companies were owned by a trust in Cayman Island. They were not owned as Q1 by any of the entities of the Carlyle group. And as a guarantee, as a security for these bonds, what then happened, or at the same time what happened, is that Q1 transferred title to the commodities to 2014-1 and 2015-1, and that 2014-1 and 2015-1 then transferred title to State Street Bank, who was a trustee for the holders of the bonds. Is that how it worked, Mr. Ordway and Mr. Yohei?
Probably when you say bonds, you mean notes.
Notes, sorry.
No. Yes.
Notes.
Yes.
I apologize. For me, bonds and notes.
Sure we understand each other.
I apologize. I meant, of course, notes.
Yes. In part, Professor, you have some of that correct. Some of it is not exactly correct. Q1.
Okay. Why don't you correct me, put it exactly right?
Q1 retained some of it for itself. It did not transfer all of it to the 14 fund. Your comment suggested that it transferred all of the title to the 14 and then to the trustee. That's not quite right. Q1 retained some of the commodities for itself, for its own account, which is why on the chart, I don't want to get into too much argument, but why on the chart where they have no transfer listed or no information provided, there was nothing to provide since it kept it. It's still
because Q1 made some profit on these transactions. It made some profit for its ultimate owner, which was the onshore feeder.
In the
financial world, nothing is done if there is no profit.
No, but on the open transaction, since they didn't close, I can't really say that they made a profit. Maybe you could say it would have made a profit had they closed.
The profit would come when they closed.
Yeah.
Okay, but they intended to have a profit.
Yes.
Yes, yes.
And so they retain a small percentage of the title on the securities because it exercising the put option on this sliver of securities, they would make a profit when they closed out.
No, they retained, no. I mean, what they were retaining was a large chunk. It's set forth in the chart, tens of billions of dollars. That was not only the profit, that was the commodities themselves that they were retaining, because they were the entity that faced Samir, and they would then sell the commodities back to Samir. So if it had closed, they would sell it back to Samir. It's not just the profit piece, it's the commodities that they were holding.
Yeah, but in the meantime, since the bondholders had to have some security, because 2014 is basically has very little capital, if any. So the bondholders needed some real security to buy these bonds. And the real security was the title to the commodity, which was held in trust on their behalf by State Street Bank. Is that correct?
For its own, for the 14 and 15, yes. But I think the confusion here is there were three sources of funds, Q1, 14, and 15.
Yes.
They were all separately sources of funds. They were pulling from each of these sources of funds. So I think the way you're looking at it is more focused just on 14 and 15, but there were really three separate sources of funds. That's the issue that I think your questions may not be exactly correct on.
But yes, of course, 69 million plus the swaps came from Q1. Yes. I am now only focusing on the 235 million and 37 million of 2014 and 2015.
Yes.
Only on that portion of the fund.
And you are correct as to that portion.
Okay. So on that portion, the way it worked is Q1 transferred title only on these portions to 2014-1 and 2015-1. Then 2014-1 and 2015-1 transferred title to State Street Bank as trustee for the note holders. And when you had to close out the deal, then the whole chain went back the other way.
Exactly
State
right.
Street Bank gave it back to 2014. 2014 gave it back to Q1, and Q1 exercised the put option and got the money from.
That is correct. With the only clarification that when you say the trust owned it, it owned it on behalf of the note holders, which is
of course, on behalf of the note holder. That was really the security of the note holder.
Yes.
Because the note holder had no action, neither against Samir nor against any Carlyle company. They basically had action only against the oil. Right. Financially speaking, this is the way it worked. Yes. So this is why it was a fundamental security. Well, the only security basically for the bondholders.
Yes, we would say ownership, security, but we're not going to argue about that.
Okay, yeah, it is the ownership as a security for the bonds. Ownership. Because the bond is a debt. It's a debt instrument. So to the debt, I don't know. Maybe under American New York law, they were the owners. Would you say that the bondholders became the owners of the commodity?
I would say the fund owned the commodities, and the bondholders had a a legal contractual interest. That's what I
Very
would
good. Yeah. So I think, thank you very much for clarifying this, so that I don't think I have any further questions. Mr. Harris, do you have any comment as a consequence of these questions?
Only I have one comment as a consequence of these questions, and there's one other point I need to raise before we finish. The only point on these questions is you will find, if you want further confirmation of the separate legal personality and status of Q1, Mr. Travers addresses that in his first report in detail and makes quite clear that it is a separate legal entity with separate personality. It is different from an LP, a limited partnership. It's a company.
Yes. Yes, and the LP is in the case of Korea. Korea was an LP and had no legal personality. I reviewed that decision by Klaus Sachs, and it was an important point. Yeah.
Sorry, there was one other point that I should just mention. So I've been reminded by others. When you look at the table at Council Memorial page 55, Samir 1020, that transaction, there's no mention of Crimson physical commodities there. And it was, as far as we understand it from the claimant's documents, it was this completely separate entity, which they've not told us anything about, Crimson Financial Commodities, which financed that transaction. And we've set that out in our reply. Let me try and give you the reference to that in a moment, but it may be that slipped under the radar.
Mr. President?
Yes, I to be very frank, that had also, if that is true, that had slipped under my radar. Mr. Ordway, do you have any comment?
I was going to add, and we can detail this further on Friday, but that entity was an entity that was like the other, like 2014 and 2015 one. It was a U.S. entity that was created by Carlyle. So we can go into further, add further information about that. But
and Mr. Zuick can even explain that tomorrow.
yes, absolutely.
Okay.
Okay. There's nothing being hidden about that entity. We're not trying to hide anything about it. It's a very straightforward vehicle, just like the other vehicles.
Okay.
For the respondents' part, we'd rather that the claimants and Mr. Zuick don't now start putting new evidence into the record. We raised this in our reply memorial, and if they wanted to put in evidence on it, they should have done it in their rejoinder. It's paragraph 79. If you want to see where it's written, and footnote 2.1.
I think we're merely, you've raised the point. We're merely addressing the question because you've raised it and you listed it and you're demonstrative. So
I raised it in my reply.
And your reply.
Very good, very good. So there is a slightly different structure in 1020, but that is the only, let's say, case which is different.
Yes, the point was just that you don't take the table at 55 as being definitive because it's wrong, at least in that respect, and we say in some others.
Well, we take issue with that, and we can deal with that on Friday.
Yes.
Because the table at 55
in your table, you say it's Crimson Physical Commodities.
Correct.
Because you have a table too. You sent a table yesterday. I see. Okay, but this is a minor point. It is one single transaction. At least I think it has been very, very helpful, Mr. Yohei and Mr. Ordway. Thank you very much because now we have the situation much clearer. So, anything else to add for today?
There's one point I said I had to mention, members of the tribunal. If I've been asked to make the point on slide 59 of the claimant's presentation, that slide included a map or a purported map of the Kingdom of Morocco,
I knew,
which failed to include some of Morocco's sovereign territory in the Sahara region. And the Kingdom of Morocco wishes me to put it firmly on the record that it does not accept or agree to that map as presented by the claimants, and it regrets that that map was chosen.
Yes, I saw it when it was shown. I was at the point of intervening. And can we all agree, in order to avoid an issue, can you take away that picture from there? Because you know the problem about.
No, the problem. It's been.
And I think it is completely. It is an issue which is important to the sovereignty of Morocco, yes. And there have been recent developments. I saw it, and thank you, Mr. Harris. To drawing our attention. Let's take it out.
We would be glad to take it out, Mr. President.
Yeah, let's take it out, because it's it is one of these mistakes which happen. It happened also, say, with the Spanish flag. We have changed our flags through history, and sometimes, and we have also changed our national anthem in history, and sometimes the wrong flag is shown, and that is all were for states. It's a very sensible issue, and the map of Morocco is, of course, very, very sensible. And so let's just take that slide out and solve it that way.
We'll remove it, and obviously no disrespect was meant.
No disrespect at all. Was it?
So apologies for that.
Yes. So with that, and thank you, Mr. Harris, for that.